Hello, my friends. And thank you so much for coming to this casual Saturday edition of my show on Saturday, November 4th. I can't believe it's already November 4th. Wow. So we were going to talk about Maya yesterday, and then, life got in the way. I have a lot of kids and things happen. And what is it that they say about best laid plans? Yeah. Well, the best laid plans didn't work out yesterday. So we are here today. And you know who we have in the chat, which is so interesting? Christine is a viewer, and Christine's niece is married to Dr. Corcoran. Dr. Joseph Corcoran, who is going to turn out to be, in my opinion, the star witness of this trial in many, many ways. He's brought up a lot of interesting things. He's caused a little bit of scrambling from the defense. And I said from day one, when we watched his testimony, we did that Battle of the Experts video where we put Dr. Corcoran's testimony up against Dr. Mark Anderson's testimony, who is the expert witness for the defense on the same subject matter, which is hospital policies, procedures, and protocols, that I thought that he was a class act. I mean, he came in saying he wasn't even being paid. So, and he's been available every single time they've needed him. He's dropped everything. He's come in. He's well-spoken. He's well-dressed. He's easy to look at, let's say. He's so kind. He speaks so nice about his family. And I think that he makes a great witness. And as we've spoken about many times on this channel, a lot of times cases are won based on, the veracity in the jury's opinion of the witnesses and the likability of the lawyers and how they feel about the lawyers. Because this case is so tangled. There are so many issues in this case that it is hard to even talk about pick one of them to even talk about today, which is why there's no way that we can even pick one. So, I mean, it's like all of a sudden, when I first started covering this trial, I think the first episode that I did on this trial was we did an overview of the case before it started. And then I did the second episode was on opening statements. And then I've been, covering it not sporadically, but throughout, but only picking out portions of testimony that I think are key or that we that need discussion. I mean, there's a lot of fluff in here that really I don't think bears a whole lot of weight on the jury's decision. But in the beginning, when I first did that show, it got like no views, like nobody was interested in this case. And now all of a sudden there's been an explosion. I mean, the views on Law and Crime have gone to barely nothing to, 150,000 views per stream, which is a lot for them. So I'm going to just take a little look through the comments here to see what you guys want to talk about, because I had an idea of what to talk about. And one thing that I want to talk about is Maya and Maya's testimony, because a lot of this is going to hinge on Maya's testimony. Because as we've discussed in the past, this case, if they get past liability or fault and they get to damages or money, the amount of money that they award, if they get that far, is going to depend a lot on Maya's testimony, because these are damages for Maya. They're also, there are some emotional damages for Jack and Kyle, but the damages are twofold. They are pecuniary loss, which is a tangible loss of income, which can be computed by an economist. And we've seen an economist testify in the first part of this trial about what her potential loss of income could be. But most of the damages in this case are emotional damages. And those can be very hard for a jury to quantify. And while some people have said that they think the jury is not going to be out for very long, I disagree. I disagree, you guys. This has to be a unanimous decision on the part of 6 jurors, one of whom may or may not be disqualified. And we can talk about those motions if you want. But they are going to have to decide on each remaining cause of action. And listen, I need an assistant because I don't even know how many causes of action are still remaining based on all of the directed verdict motions and all of the causes of action in the 8th amended complaint, which is the one that we're going on at this point. which ones have been granted summary judgment, which is before the trial happened, which ones have been granted a directed verdict. So I don't even know how many causes of action still remain. But they are going to have to decide on amounts of money that they think this case is worth. And I think that's going to take them a long time. So I really don't think this is going to be a quick verdict. They're going to have to talk about all of the evidence with regard to each count, or each, it's not criminal, cause of action. It's a civil case. So each cause of action. And there are a lot of them. And I've said from the beginning also, this is a tragic case. Tragic what happened to her. It has brought awareness to a lot of things, and it has brought awareness to CRPS and other chronic pain disorders and diseases, and how difficult they are to treat, how difficult they are to diagnose, and how before this trial, so many people, other than those in my chat who have CRPS, and I know there are a lot of you, even knew existed, how it's so difficult to find a doctor that will listen to you and will understand you and will not gaslight you. And I did a show the other night with Dr. Kave, who has a YouTube channel called Medical Secrets. And I did that show with him. I called him on the show, and we did. I thought it was a great show. If anybody watched it, let me know if you liked it. We did a whole show on K therapy, and he offers that in his clinic in San Francisco. He's a firm believer in its efficacy for depression, anxiety, addiction, and chronic pain, and how many patients are gaslit by doctors, and what to do if you're being gaslit by doctors who are telling you, oh, you're not really in that much pain. It's all in your head. And I think he's a very kind and compassionate man. And I loved that you guys sent me his video, and that's how I found him. And then I just emailed him and said, hey, do you want to come on my show? Because I'm trying to raise awareness for CRPS and all of these other chronic pain issues that my viewers have, and they're not believed or taken seriously, and nobody gets it. And it's so, I thought it was a great show. So if you haven't watched that show, go back and maybe check it out. I also designed a line of Team Maya merch, and the merch, which is linked below, and also in my store tab on my page, all of the proceeds of those shirts are going to go towards CRPS research. And I haven't decided which charity or foundation to donate them to. So I'm taking suggestions on that as well, because I know that a lot of them are not as well regarded, highly regarded as others. So that's open for debate. And a lot of you have been purchasing those Team Maya shirts. So thank you for that. I think that that's, something that we can make a positive out of this very tragic case. It's also shining a light on the private DCF system and how DCF can take away your parental rights based on a 10-minute, not even interview, by an outside CA doctor, in this case, Dr. Sally Smith, who may come into your child's room and have a discussion with you for 10 minutes, and based on her own findings, call the CA hotline or report back to the DCF that you are making up your child's symptoms, you are committing CA, take away your parental rights, and your child can become a ward of the state. And as we know, Maya was in hospital or state custody for 87 days until her mother took her own life, and then for even another week after that, until the court decided to reverse its decision and give her back to her dad. Tragically, it was too late. November is CRPS Awareness Month, is it? Thank you, Sweet Tea's Treasure. Is that a new thing, or has it been that? Has November been CRPS Awareness Month for a long time? Okay, yeah, KD 214. I'm very curious to see what will happen with the deposition that happened yesterday. Okay. Is anybody on the inside of this case? Because there was supposed to be a deposition yesterday at 4 p.m. And the hospital was required to produce somebody with knowledge of the internal, hold on a second, knowledge of the Joint Commission reports But then there was a filing yesterday at 4 p.m. It's a motion for clarification that was filed by the defense, and it's 178 pages. And they locked it in the court file. They're saying it's confidential, so it's been locked. When I pull up the correspondence filed by the defense, Howard Hunter, this was filed yesterday at 3:08 p.m. It's a notice of confidential information within court filing. Maybe I can put it up on the screen for you so you can see it. I am so guilty of having too many tabs open, and you know that is my problem. I always have too many tabs open. And I don't even know if this is the right tab, but let me see. All right, so they filed this notice of confidential information within court filing. And this was filed yesterday at, as you can see up here, 3:08 p.m. So this is the deposition was supposed to take place at 4 o'clock. And it says, this is the confidential information that we want the court to seal because, as you know, if you go into the court file, you can pretty much access all of the documents in this case. And it says the title or type of document is Defendant Johns Hopkins All Children's Hospital Supplemental Disclosure and Motion for Clarification on November 3rd. So they filed this, today's the 4th, right? Yep, they filed this yesterday. And they're saying the confidential information within the document is the entirety of exhibits A, B, C, D, and E. All right, so this was filed yesterday, 3:08 p.m. by Mr. Hunter. And then when we look at, well, yeah, it is sealed because they're confidential. So I think they want the judge to review these documents in camera, which is in private, and decide whether he wants to release them and if they are going to be released. So this deposition, according to the plaintiff's notice of deposition, was supposed to take place yesterday at 4 p.m. So on the eve of this deposition, or the hour before this deposition, they ran in and filed this motion. So I do not know for a fact whether this motion, whether the deposition took place. Let me show you this document because everybody likes to look at documents, right? Let's see, is this it? Let's view PDF. No, that's the motion. Hold on one second. Should be this one. Okay, so this is who they wanted to depose. And they wanted to depose a designation of corporate representative pursuant to, I don't need to read this to you because you can read. And this is the person that they wanted produced needed to be a person who could testify on these issues and matters. So they could pick, the defense can pick whoever they want as long as that witness has personal knowledge of these three things. Number one, any and all interactions with and/or surveys conducted by the Joint Commission, CMS, AHCA, or any other similar accreditation or governing entities between 2012 and 2019. There's a wide period of 7 years. Number two, any and all corrective action plans and/or similar improvement efforts taken by Johns Hopkins All Children's Hospital at any time between 2015 and 2019. And number three, any and all self-reports and/or findings, surveys, reports, and/or classifications of immediate jeopardy and the reasons therefore. So that's the witness that they wanted to depose. Does anybody know for a fact whether that deposition took place? Can anybody confirm it? I don't know, cat lady. Didn't the clerk file that the defense didn't provide what the judge asked for? It looks, I mean, they provided 178 pages of stuff under seal. So it's been locked. So I'll show you what it looks like when I look in the court file. This is what comes up. So you can see these are all the documents. I mean, there are maybe 50,000 documents already filed in this case. At the top is the latest filings. So if you look here, this is the case number. This is the caption of the case. It tells you the judge. It tells you all of the appearances, all the motions. Up here, up top here is all of the appearances. And that they're scheduled to go back in on the 6th, which is Monday at 8:15 a.m. Tells you all the fees that they've paid to file all of their documents. And the last thing filed was this notice of confidential correspondence, which we just looked at, and this motion for clarification, which is 178 pages, and that has been locked and sealed, so we can't get to it. There's also a notice of filing, which is 88 pages, which we cannot get to. Then there's this notice of confidential information with court filing, so we can look at these. These are just letters. And then we can look at the motions to the motion and the response to the motion for disqualifying the juror. So that begs the question about whether or not this deposition happened, and I don't know. Yes, I did see that too. Keep looking at the paperwork. There is something from the court that says this is not going to be kept confidential. They have a certain amount of days to get it to the, no, what happened? So there's this letter. I mean, the judge is going to rule on this by Monday. He has to. This trial has to go ahead. He promised the jury that it was going to be over. Okay, so yeah, here we go. So this was filed. The clerk of the court served this yesterday at 7 p.m. These people are working late. They're working overtime. This is Eastern time. So the clerk of the court is doing this at 7 p.m. yesterday. And she served upon Mr. Hunter this clerk notice of noncompliance and request for compliance with Florida General Practice and Judicial Administration Rule 2.420. If anybody wants to look that up, they can, what that judicial administrative rule is. But it says the Sarasota clerk of the circuit court has reviewed your filing dated November 3rd, which was identified by you as containing confidential information. And she checked off this box. The clerk has determined that the information in this document is not subject to confidentiality as noted in the Florida Rule of Judicial Administration 2.420 D1B. This record shall not be held as confidential for more than 10 days from the date of this mailing unless a motion is filed pursuant to subdivision D3 of the Florida Rule of Judicial Administration 2.420. And then we see that the motion was filed. So the motion was filed. So it's all fakakta, you guys. I don't know what to make of this. I don't know if they did the deposition or not, but it's interesting. It's 178 pages of something. Let me see if I can. It's a motion for clarification. So it's 178 pages. And my guess is, from my experience, that Hunter is turning over 178 pages to the judge and saying, Judge, tell us what you want or what you are requiring us to give the plaintiffs, because we don't know if all of this is admissible, necessary, discoverable. It could be a bombshell. It could be nothing. What are your thoughts? Somebody said it's blurry and they can't read it, but it was fine for me, so I don't know what kind of device that you're on. He knows exactly what. Why can they seal it? Because some of it may not be admissible. It may not be discoverable. It may be outside the scope of what's discoverable in this case. You're not entitled to everything all the time. And it was a little bit sketch in court, what they were being required to turn over. It wasn't usually a discovery demand has to be pretty specific. And you have to say, these are exactly the things that I want. And these are exactly the things that we want you to turn over and produce. And a lot of times if you say, we want any and all correspondence between these 7 years, the judge may say it's unduly burdensome and it's irrelevant. And if this, there was some discussion about whether these Joint Commission reports or CMS reports only had to do with the cardiac unit, whether they would even be admissible in this case. There's a lot here. Yeah, the judge did seem so irritated, right? He is a great judge. I think he's got a great demeanor. He's very friendly with the jury. The jury seems to like him. They seem to joke a lot. Oh, Tennille Suzanne, yeah, you think Hunter? She says, I think Hunter is going to make it hard to get what the plaintiffs actually want. Of course he is. Weren't these the Dracula files that he said he put away? Hi, Janelle. Is it normal to submit things as confidential if it's not actually confidential? It doesn't happen a lot here in New York. This is a different animal, you guys. We're in the wild South right now, the wild Florida. We don't even let jurors ask questions in New York. That's a very, very unusual thing for a judge to do. I don't know if it's done in every single Florida case or if that's at the discretion of the judge, but that does not happen here in New York. In New York, if you're the lawyer, it's your job to get out the evidence that you want out. And we do not entertain jury questions here. So this is a really interesting thing. And, that's why it's a slippery, slippery slope. If you're going to allow the jury to ask questions, you can't, and you pick the jury as the attorney, you can't then turn around later and say, well, I think this jury has bias because they're asking questions in such a way that's not favorable to my side. Jurors do not leave their common sense at the door when they come in to hear a case. Everyone comes in with personal experiences and personal stories and occupations and certain knowledge. And I mean, we can look at this motion to disqualify the juror, and we can look at it. I don't have to read you every word of it, but it's interesting. So why don't we take a look at that since we're here? Then what I would like to do is go back and look at some of the stuff that happened with Maya this week, because this, everyone's focusing on this Joint Commission report and this immediate jeopardy stuff. And, it may or may not, I don't want to say be a smoking gun, but I don't think that it's as important as so many viewers are getting caught up in, because I think that even if there is, and I'm not saying that there is, but if there is a Joint Commission report that put the hospital in immediate jeopardy of losing their accreditation, I don't know if it's going to be admissible. It may be more prejudicial than probative. And there could be a curative instruction for the jury to just disregard all of expert Mark Anderson's testimony. Because when we went over his testimony, we found out that he did not review those Joint Commission reports, although he referred to them in his testimony. What he referred to was a synopsis or a summary or a couple of sentences in an outline that the defense attorneys provided him with. So he didn't go out and seek out the Joint Commission reports. He didn't ask the defense attorneys to provide him with copies of them. But his testimony was pretty much based on, and tell me if you think I'm wrong, a summary that he was given by the defense attorneys, which is ridiculous and shouldn't fly. And the judge can instruct the jury to disregard his testimony in its entirety, or he can instruct them to say that based on what I've reviewed in camera, Dr. Anderson's testimony was not credible with respect to his testimony on the Joint Commission reports, and therefore you should disregard this part of his testimony. And if you find that he is not credible in this part of his testimony, you are free to disregard all of his testimony. If there's a curative instruction that can be given, and I don't think it's going to cause a mistrial. I hope it shouldn't. Nobody wants to try this case again. It looks like they're just trying to get to appeal. So unfortunately for them, Mark Anderson was a hired gun. He was paid $5,600, which in my opinion is way too low. A lot of doctors that I know that come to testify in New York, especially surgeons, they can charge $20 for $20, not $20, $20,000 for one day of testimony. And that's not including their hourly rate and the rate that you've paid them to review documents and 1,500 pages of medical records before the trial even starts. So, Julie, thanks for coming to watch over college football. You can always have it on in the background. Look, my Buffs are not playing until like 10 or 10:30 tonight against Oregon State. So go Buffs. I know there's a lot of you from Oregon. But I think you're Oregon fans, not Oregon State fans. So that's why I'm here doing this today too, because if my Buffs were playing at noon today here, which would only be 9 a.m. or 10 a.m. in Boulder, I'd be doing this later. So thank you for that, Julie. I appreciate your dedication to this trial and its coverage. So let's take a look. Okay, let's see what you see here, D. If the hospital was in immediate jeopardy, that happened over time. The hospital is given many chances to make changes before immediate jeopardy. If this was done because of routine inspection, a complaint is different. Yeah, there's a lot of nuances to this that I think a lot of people who are screaming about it do not really understand what it is. And so I don't really think, I don't know what's going to happen, but I don't even know if that deposition even took place. So this is going to lead to more delays. So let's take a quick look since we're here and I already have it pulled up here about the motion to dismiss juror number 1. So if anybody here, is juror number 1 the one who is in law enforcement? Fill me in on juror number 1, because I know you guys are so on top of this and you're watching it daily. Did I close that? All right, here it is. The motion to disqualify the juror. I'm a little disorganized today, so excuse me. Juror 1 is not former law enforcement. I think it is. Hi, I'm Melissa. Yes, Danielle Alexander. Hi, Danielle. It's nice to see you. I think juror number 1 is Polish. Yes, and I think let's take a look. Let's take a look now at the motion, because they do talk about him. I think it's a him. All right, let me know if you guys can see this big enough for me. All right, so this was filed on the 2nd. Let's get rid of this. 2nd, which was Thursday at 4 p.m. They have such a big team working on this that it's amazing that they can be in court all day and they have all these people working behind the scenes to make these motions. If you're a solo practitioner, I don't know who you have doing this for you, but as we know, the defense has a huge team working for the hospital on their behalf. And I'm not going to diss defense attorneys, because some of my best friends are defense attorneys who happen to defend hospitals and doctors for a living. That's what they do. And a lot of my friends are doctors. Oh, and let me show you something. I just want to show you something real quick before we do this. Speaking of, I don't know if he's even in the chat today, but anybody know what a Funko Pop is? Because I didn't know what a Funko Pop was until I found this in my mailbox. And my daughter said, "You got a Funko Pop? Where did you get a Funko Pop?" So anyway, this is a Funko Pop. And it's a little figurine, and it says Attorney Melanie, and it looks like me. And look, she's got a little cupcake. Isn't that so cute? So you can have a Funko Pop made for anyone that looks like them. My ring light is not making this very visible. But thank you. You know who you are, who sent this to me. I appreciate it so much. It's so adorable. Isn't that so cute? I didn't take her out of the box yet, but great Christmas gift idea for anyone who's looking for something really cute and original to buy for a friend, and you design it to look like them. And he's a doctor, so somebody made one for him, and he has it on his desk in his office. And yes, you can create your own Funko Pop. And who knew? I didn't even know what it was, but thank you. I appreciate it. What a sweet gift. So kind and thoughtful. Okay. Here's the defense motion to disqualify a juror. Again, filed on Thursday night, Thursday late afternoon. And here are the reasons why. The defendant submits that juror number 1 on multiple occasions and through multiple questions and statements communicated to the court in connection with questions has revealed a bias and prejudice in favor of plaintiff and against defendant, and a violation of this court's instructions to the jury not to form or express any opinion about the case until retiring to the jury room to consider a verdict after having heard all the evidence, the closing arguments of the attorneys, and the charge of the court. And here is their reasoning, which is basically, we don't think this juror is on our side, so can you please excuse this juror and put in somebody else? And this is also another example of you better want what you wish for, because if you have this juror excused and this juror is replaced with somebody else who even will award more money to Maya if it gets that far, you know, hindsight's always 20/20, right? It's a risky move. But in any event, their allegations are as follows. Throughout the trial of this cause, I don't know why they say cause in Florida, I would say case, but throughout the trial of this case, the jury duly sworn to hear this case along with the alternates appear to have paid diligent attention, and their attention has been reflected in a substantial number of juror questions. Okay, again, like that's a bad thing. They've been paying attention, and they've been paying such good attention and taking such great notes that their questions are amazing in a substantial number of questions. So do you not like the fact that the jury is asking so many questions, and so many questions that maybe you are interpreting as not good for the hospital? Because really that's what this is about. In the process of posing such questions, however, one juror, identified as juror number 1, has repeatedly revealed not only a substantial bias and prejudice in favor of plaintiffs and against defendant, but also a violation of this court's instructions as set forth in Florida Standard Jury Instruction 1.1, that he or she, quote, should not form or express any opinion about the case until you have retired to the jury room to consider your verdict after having heard all of the evidence, the closing arguments of the attorneys, and the charge of the court. Again, you know, you can interpret these questions however you want to interpret them, but you know, trying to assign some bias to the wording of a question, I think is a little tenuous. And I'm going to say it, but listen, if you're grasping at straws and you're afraid of a really big verdict, then I guess this is what you do. 2, juror number 1's statements evidencing the above include, but are not limited to, the following. Most recently, in questioning Nurse Sylvia Ballweg, a witness called by the defendant. So again, this is a question that this juror asked about of their witness. The juror prefaced a question by making a statement to the effect that the witness was, quote, a breath of fresh air, end quote, or words to that effect, since she was the first person from defendant who appeared to have cared about Maya Kowalski. All right, so again, why are you saying or words to that effect when you have the ability to go back on YouTube, by the way, and watch the testimony of Nurse Ballweg and the jury questions immediately after, and you can actually quote the question word for word, because we have that ability. So why, again, it's a little vague. Why say or words to that effect? Why not quote the exact question? Because you have the, even if you're not paying for the transcripts daily, which I'm sure that they are, because remember, the court reporter can charge them daily for transcripts, and they are very, very expensive to get. Just go back to YouTube and look at what the question was. We have it. B, in a question to defense witness Kelly Thatcher, and Kelly Thatcher was the nurse who testified that Beata told Maya she was going to give her a reward, remember, of Valium. I think it was Valium or a painkiller if she did something. Juror number 1 asserted that his ethnic background was the same as the decedent, Beata Kowalski, with the result that both the juror and the decedent tended to be, quote, pushy. Juror number 1 stated specifically that he identified with the decedent and questioned whether the witness had overreacted to the decedent, suggesting a belief that she had done so due to the decedent's ethnicity. Again, instead of putting your spin on what you think that juror's bias is and what you think that juror said, put the exact question in there word for word. I don't like this. This is poorly done, and it's putting a spin on something. Quote the exact question. Go back to YouTube and watch it. So I don't like it. C, juror number 1 asked a question of an early witness stating, quote, there appears to be probable cause of improper action by and of Sally Smith in her assigned role at JHACH, thus indicating that the juror had formed and was expressing an opinion regarding the case and the evidence in violation of the court's instruction and indicating a predilection against defendant. Again, who's the early witness? What is the exact question? I'd throw this out. It's not specific enough. D, juror number 1 expressed an opinion in preface to questioning of witnesses indicating, quote, an understanding of CRPS can come and go, get worse, or reside/disappear, thus reflecting not only an opinion about certain matters and issue, but an acceptance of plaintiff's evidence before having heard defendants. Again, jurors don't leave their common sense at the door. And this juror's opinion can shift. So, I don't know. I think this is kind of weak. E, questioning various witnesses called by the defense, including Charlotte Laporte, in an adversarial manner. Again, adversarial manner. This juror did not read the question directly. This juror did not stand up and raise his hand and ask this question. We don't know the tone of voice that this question was asked in because it was on a piece of paper and it was read by the judge. So saying that it's confronting her with questions in an adversarial manner, it all depends on the tone of how you read the question. Try reading it in a different way and you'll get a different tone, right? Regarding whether she can, quote, beyond doubt affirm that, end quote, or whether she was, quote, able to attest, end quote, to certain matters she addressed. So now they don't like the verbiage? They don't like the fact that this juror seems to understand the lingo? You know, I don't know. The juror's too smart. Specifically those related to Catherine Beatty and telephone calls, again, indicating an adversarial predilection against that testimony in favor. Wah, wah, wah. This juror doesn't like us, judge. Please take this juror off the case. F, questioning witnesses, including Tori Neas, who we did watch her testimony. That was the pink shirt lady, as some of you are calling her, as to whether, quote, her team or, quote, the hospital possessed a certain photographic or video evidence. By posing this question, hi, Donna. Yes, Donna, I'll take care of it. Long before testimony has been concluded or arguments submitted, the juror has indicated that a burden has been placed upon the defendant above and beyond any contemplated by the court. Again, there's no exact question here. It's the defense's interpretation of that question, and that's what I have a problem with. If you're going to make these arguments, you need to put the exact question in there so that the judge can decide this properly. The judge shouldn't have to go do outside work. The judge shouldn't have to make his intern or his court clerk go out and find the YouTube videos and find out what the exact questions were so that he can interpret them. It's just kind of, I don't like it. Again, in questioning Ms. Laporte, the juror in question begins a question with a representation that plaintiffs had provided address from Maya Kowalski to defendant or Ms. Beatty, indicating a prejudgment of the evidence with respect to that issue and without having heard all of the evidence. In the same question set, the juror in question confronted Ms. Laporte with questions regarding whether she knew the dress in question resided in the office and whether the witness knew it was not timely given to her, indicating an acceptance of plaintiff's evidence before having heard all of the same. Questioning at least one witness with the preface that plaintiff Maya Kowalski was more mature than a usual 10-year-old and or handled her pain differently, thus expressing opinions that reflect acceptance of plaintiff's evidence and testimony, blah, blah, blah. Questioning witness Stephanie Graham in an adversarial manner regarding statistics related to the success of her case ratio and also regarding her interrogation of plaintiff Jack Kowalski, despite the witness's own testimony that the discussion in question with Mr. Kowalski was an interview, not an interrogation. Yeah, that's the witness's testimony, but the jury has the right to disregard that, indicating an adversarial attitude and bias against the witness. Questioning witness Elliott in a sarcastic and biased manner. Again, tell us the question. Tell the judge the question so he can make the determination. He shouldn't have to go out and do extra work on this. Questioning witness Billy Seisel after a preface referring to him as a, quote, newbie, indicating a bias against the credibility. Questioning witness Billy Seisel after prefacing the same with, is it possible that Maya's waning abilities could be contributed to JHACH, causing the limiting of family interactions? The stress and the trauma Maya has testified to, documented statements by Maya about her mother's status told by the hospital staff, Ms. Beatty. The juror statement not only flies in the face of this court's instruction to the jury regarding the role of DCF, but also accepts as true plaintiff's evidence long before having heard all of the evidence, as well as an opinion regarding the evidence. And it goes on and on and on. Questioning Sally Smith. And so they've got a lot of questions by juror number 1 that they don't like. But guess what? They had the opportunity to object to all of these questions by this juror during those sidebars with the judge. And I didn't go back and look at every single question that's mentioned in this motion and whether or not they objected to these questions being asked. And Recovery Addict, who does an amazing daily live stream of this, has the Zoom feed, and occasionally he can hear what they're talking about during these sidebars about the jury questions, and he repeats them. But most of the time, because I do watch his stream occasionally, they say no objection, and the judge asks the question. So again, should the judge have to do all of the work and go back and read the transcripts and see whether they objected to all of these questions being asked at the time? Then they go on to say, oh, hang on one second. I don't have any mods in here, so I just got to mod somebody. Hold on one second. Which I will do when I put on a video. They go on to give their opinion and their arguments about what the standard is with regard to removing a juror for improper behavior. And according to them and the cases that they found, because like I tell you, there's always a case to support your position. A party seeking to remove a juror for improper behavior in the course of a trial must show the juror's actions amount to misconduct. Okay, that's going to be a question. Do these questions, rise to the level on misconduct on the place of a juror? I don't think so. The next prong of their argument: a trial court must excuse a juror where there is reasonable doubt whether the juror is impartial. Listen, that is something that the attorneys need to figure out during voir dire. And if you allow the jury to ask questions, you can't then disqualify a juror just because you don't like the way they're asking their questions, the tone that you interpret their questions to be asked in, and the verbiage that they use in their questions. Reasonable doubt as to a juror's impartiality should be resolved in favor of excusing the juror. During voir dire, they always ask the juror, can you be impartial? Can you be impartial in this case? Yes or no? They answer yes or no. And remember, they picked this jury. 5, while the trial court is offered great discretion in ruling on the challenges of jurors for cause, close cases involving the challenges to the impartiality of potential jurors should be resolved in favor of excusing the juror rather than leaving doubt as to impartiality. Cite some case law. And they say, and here's why we should win. Let's wrap this up into one little paragraph. In light of juror number 1's apparent prejudice and bias revealed throughout the course of the trial through his questions and demeanor, we think it's obvious, Judge, that you should disqualify the juror. As a practical matter, moreover, obvious bias on the part of a juror risks a hung jury if other jurors believe the juror in question has violated his oath. Finally, no party will be prejudiced by removing juror number 1, given that an ample number of alternatives have been chosen. And the alternatives in question appear to have been every bit as attentive as the primary jurors. And then they go on and talk about a couple more cases. And then they say, although Florida case law is not uniform on whether questioning a juror before disqualification is necessary, this case Allberger supports the proposition that the act of questioning a juror under the circumstances at issue could reinforce his or her prejudice or bias without cause. In addition, given the extent of juror number 1's apparent bias, prejudice, and failure to follow instructions, any questioning by this court would serve no useful purpose, given that the juror is well beyond any rehabilitation and would risk alienating not only the juror. So they're saying, basically, Judge, just excuse this juror based on our arguments. You shouldn't even question the juror because it wouldn't do any good. Any questioning that you would do of this juror would not do any good, and therefore you should just excuse this juror based on our opinion that we think this juror has bias. What do you think? What say you? What say you? Yes. Legalese, the fact that they don't even want the judge to ask the juror questions is crazy. Yes, but remember, okay, this just takes me back to Murdoch for just 1 second. Facebook lady, Egg Lady, right? Her name was Egg Lady, the juror that is the subject of this whole motion for a hearing to get Murdoch a new trial based on jury tampering by the clerk of the court, Miss Becky Hill. So Egg Lady was questioned privately by Becky Hill, the court clerk, during the Murdoch trial, and brought into a room by the clerk and questioned about certain Facebook posts that Becky Hill alleged that juror Egg Lady's ex-husband had made regarding the fact, allegedly regarding the, because these Facebook posts were never found, that she had told people about the case and what she was thinking about which way she was going to rule on the case, vote on the case. And the judge brought Egg Lady in and did question her about it. And during a conference, I think that was in chambers, the judge is on the record as saying, I have a real problem that the clerk questioned this juror outside of my presence without bringing this to me. That is clear jury tampering. So the judge did bring the Egg Lady juror in and asked her questions. And based on the answers to those questions, he excused her. So this is something that is a slippery slope. Let's see what their... Hi, Dakota. All right, you know what, Dakota? I'm going to mod you so you can police the chat. All right, let me just get in here for a second. Donna Marie had to leave, and we need some additional mods. So hold on. 1 second. Let's look at their response to this. All right, Dakota, welcome to your wrench. Use your power accordingly. Kick out the bullies. We don't tolerate that here. No bullying. Everyone has to be nice, classy. And where's my little sign? Here you go. be nice or leave. This is a safe place for everyone to watch this coverage without attacking each other or bullying or saying foul things. We don't allow foul language either. Not a fan of the cursey words. It's my channel. I'm allowed to. I'm allowed to do that. Oh, yes. Hold on one second. Hold on one more second. I didn't expect this to be a large stream today on a Saturday. Okay. Gothic Brenox. Yes, I did get your email. I know you're experienced. And so now we are back in business. Okay. Let's take a look at the plaintiff's opposition to this motion. And this was filed yesterday, right before 4 p.m. So they have a lot of people working on this too, because they were supposed to do that deposition yesterday at 4, and I still don't know if it happened. Their opposition. And I don't like how they did not number their paragraphs. That's something that is typically done in every motion. So the fact that they did not number their paragraphs is troubling to me. I don't know if it was an oversight. I don't know if nobody proofread this, but okay. They say defendant is factually and legally wrong. Probing questions do not show bias, and defendant ignores the juror asked probing questions of both sides. Defendant's tactic, if successful, would promote gamesmanship for parties who wanted to eliminate a juror during trial and undermine confidence in the judicial system. I happen to agree with that. Plaintiffs note that the parties have been provided with copies of the jurors' questions through last Thursday. Nevertheless, defendant chose to not quote the actual questions, opting instead to describe the questions or quote small phrases out of context. I just said that. And this is funny because I didn't even read this yet. Plaintiffs take issue with these characterizations and with defendant's assertion that these questions show bias in plaintiff's favor. For example, defendant describes the question in 2E as showing juror number 1 question defense witnesses in an adversarial manner by prefacing his questions by asking if the witness could beyond doubt affirm that, or, quote, was able to attest to something in the witness's testimony. Far from demonstrating juror 1 was being adversarial towards these witnesses, it more than likely shows he was only mimicking the lawyers for both parties that he had been listening to for so many weeks. I agree with that too. They've been sitting there since September 21st. He's just spitting back the words that he's been listening to. And then they go on and on with a lot of what I think are good arguments. The parties do not as yet have the exact word of juror number 1's comment and question to Nurse Ballweg, in which he stated that she was, quote, a breath of fresh air. Why don't they have it either? Why didn't they go back and watch the coverage? Don't they know this is being broadcast on Law and Crime, Court TV, Tampa 9, so many stations, or whatever that is, Fox 13? Why can't they get they can get it. They just go back and watch the coverage. It's so funny. While plaintiffs agree that juror number 1 described this witness as a breath of fresh air, they disagree with defendant's characterization of what juror number 1 meant by this. Right. Well, we can't decide what the meaning behind it was. To the best of plaintiff's recollection, juror number 1 did not explain his comment, and he certainly did not say that he thought the witness was, quote, the first person from defendant who appeared to have cared about Maya Kowalski. One possible interpretation is that juror number 1 thought plaintiff's counsel had questioned her too aggressively and that he was simply being encouraging to her. That reasonable people could interpret this statement differently. However, demonstrates the comment does not show bias in favor of the plaintiffs. They say defendant's motion also omits other questions asked by juror 1 that were either completely neutral or could be viewed as revealing bias in favor of the defense and against the plaintiff. For example, juror number 1 asked defendant's witness, Jennifer McCain, MD, regarding the complexity of medical issues without any indicia of bias. Quote, Dr. McCain, in your testimony, you've used the phrase similar to psychological component. Should I interpret that to mean there is a mental component, but there's also a physical component, or does your phrase psychological component mean there is no psychological component? Juror number 1 asked defendant's witness, Nurse Alcide, regarding issues of fact for his determination. Nurse, what color was Maya's court attire that you helped her change into? Juror number 1 asked defendant's witness, Nurse Alcide, about the timeline of events. Nurse, is this timeline and clothing correct? Helped Maya get down to shorts and white bra. Yes. Photo then taken. You helped Maya into dress with same white bra, or you changed her bra. Juror number 1 also pointed out Nurse Rex's kindness, asking if Maya's parents were negligent in not doing their daughter's laundry. Juror number 1 asked an unbiased question to the defendant witness. Doctor, if during this time, Dr. Smith, per Mr. Shapiro, was acting as a DCF employee, then is it proper for Dr. Smith to act as a contributing staff member of JHACH? And again, they've got a lot of other questions that the juror asked that they do not think shows bias, which is a good way to point this out. I do not think this juror is going to be excused. And then they go on to address defendant's argument. Defendant correctly states that a party seeking to remove a juror for improper conduct during a trial must show that the juror's actions amounted to misconduct. Defendant cites 3 cases standing for this proposition without providing any factual description of the cases or their holdings. The first 2 cases are factually very different from the situation before the court here, and they go into their legal arguments. And we will see. I don't know when the judge plans on ruling on this. I would imagine it's got to be Monday. But in my opinion, from reading these motion papers, I don't think it's clear that there's misconduct here. What do you guys think? Hey, Scott. How are you? Being a smart juror is always a detriment. Sarcasm. Yeah, they don't like it. They don't like that this juror is smart. And what? Okay, thank you, Deanna. Deanna, you could be my eyes and ears in the courthouse. Judge is ruling Monday morning on this. Good. Highland, the snark through that passage is excellent. Yes, agreed. Gothic Breenax. To ask to have a juror removed for being Polish, like Beata, is discrimination and not right. I agree. Danielle, absolutely do not see misconduct. Right. Where's the misconduct here? It's not like if they had a case where they were saying, listen, other jurors have come to us and they have told, or other jurors, let's see, they're getting emails, right, from everywhere, because we saw some photos that were shown of Maya that people are randomly, anonymously emailing, maybe not even anonymously, but there are a lot of people out there who are sending the defense information, right? Including all of these social media posts that are very anti-Maya. I would imagine that if there was some actual misconduct, somebody would have emailed them about it and they would have some actual misconduct here. But, actual misconduct would be something like, this juror is going back at lunch and telling all the other jurors that they should give Maya $1 billion, and something a little more tenuous. I mean, a little more solid than these tenuous arguments that we don't like the way the juror phrased these questions. And another issue that I have is if you're going to allow the jury to ask questions, I sort of feel like they should be asked anonymously. Why should the attorneys know which juror is asking which question? Like, they could collect all the questions from the jurors, shuffle them up, and hand them to the judge so that the attorneys don't know which juror is asking which question. I don't know why they are pinned down to a specific juror. I don't think that that's necessarily the right thing to do. I don't know. Hi, Lita. I think removing the juror after they revealed they were Polish could cause more problems. Can this juror speak to anyone after they get dismissed? Yes, they can. I'm pretty sure, unless the judge places like I don't think the juror is going to get dismissed. Number one, but if the juror does get dismissed, unless the judge gags that juror, they are allowed to speak to anybody they want. In fact, there's no gag order on this case, and I'm going to show you a clip. And I don't know if you've seen this, but Greg Anderson went out and spoke to the media on October 27th. And in my opinion, that was a really bad move because he kind of bit himself in the ass. Hi, Lady Prudence. Yeah, or the judge should give instructions as to how questions should be asked. Who'd want a juror then? Yeah. Again, this goes back to a lot of people commenting after this whole Murdoch thing happened when Poot and the other guy came out and said, all these other jurors better go out and get attorneys. Nobody's going to want to serve on a jury if they're going to have some sort of liability for serving on a jury when they're doing their civic duty and then being told they should go out and get lawyers. It's a whole other thing. Hi, Skoda. What video are you referring to? The video where he talks to the media? If you have that, Skoda, can you email that to me at fanbase@mlittlelaw.com so that I can queue it up faster? It might be actually right on here on this feed. All right. If you haven't seen it, has anybody seen this interview or this statement by Greg Anderson that he gave to the media from October 27th? Okay, let's go to, it might be right in the same page that I'm on. So let's take a look at this because he kind of sums up, it's like 7 minutes long. Let me know if you want me to speed it up, but I think we should listen to it because he kind of sums up what his arguments are. And it's kind of like a nice little summary for us about what he thinks he's proving and what he thinks he needs to prove. So what did I miss? Somebody said I missed something. You missed the most important part in bold with plaintiff's example of the previous precedent. I mean, it was the strongest part of the document. All right, let me go back to that for a second before we close that out. It's in bold, you say? All right, let's pull this up one more time. Thank you very much for pointing that out to me. Joe CH. I thought the argument was already decided, so let me just pull this up for you. This is talking about the cases that were cited by the defense in their motion. Where one of these cases, the finding was, this was actually a criminal case. This was a case that the jury was allowed to ask questions. Is this a Florida case? Let me see. It is a Florida case from 2007, Washington versus the state. This case said that the trial court abused its discretion by removing a juror based on purportedly biased questions the juror asked during a trial. So this is what the appellate court overturned. And although defendant cannot be criticized for failing to cite this case, apparently they did cite this case in their moving papers. It only did so by burying it in a string cite. Oh, that's interesting. So they threw it in there, but they didn't talk about it. In Washington, the trial court instructed jurors at the beginning of the trial that they could submit written questions aimed at clarifying the evidence and encouraged them not to ask a large number of questions. During trial, juror McCoy asked a great many questions. After all the testimony was presented, the trial court announced it was replacing juror McCoy with the alternate because, quote, Ms. McCoy was the only juror that asked any questions. A large majority of the questions asked by her were contrary to my instructions, showed a total lack of understanding of the testimony that had been presented, were generally argumentative and hostile questions. Okay, well, the difference here is that this juror, number one, his questions did not show a total lack of understanding of the testimony. So there's one difference. The reconstituted jury ultimately returned a guilty verdict and the defendant appealed. First District reversed the judgment based on the trial court's removal of Juror McCoy. And then the appellate judge rejected the state's argument that Juror McCoy's questions demonstrated misconduct by revealing bias in favor of the defendant. The court stated, Juror McCoy appears to have been skeptical of the state's witnesses, but does that, I'm going to start that again. Juror McCoy appears to have been skeptical of the state's witnesses, but that does not mean that she could not be fair. Jurors are told that the defendant is presumed to be innocent and that the state has the burden of proving guilt beyond a reasonable doubt. It should come as no surprise that some of them will have critical questions about the state's evidence. Surely a juror does not demonstrate unfairness merely by asking sharp questions. Again, agree. The court went on to observe, jurors are told that they must not form any definite or fixed opinion about the merits of a case until they have heard all of the evidence, the arguments of the attorneys, and the instructions of the law. There is nothing in the record to suggest that Juror McCoy violated this instruction. And here's the bold portion. She may have been forming impressions as she was hearing the evidence, but we do not know what she may have thought after hearing the entire case and discussing it with the other jurors. It would be unrealistic to assume that jurors do not form impressions as they are hearing evidence. That is not improper so long as the juror does not decide the case before it's concluded. Right. That's not improper. Of course, if you're sitting on a jury, of course you're going to start forming opinions in your head as you're listening to the testimony, but those opinions can change. And I'm going to show you some testimony from this week that may have changed some of the jurors' opinions. And you let me know what you think. Because I'm not sure if everyone here has watched every single minute of this trial, but there was some interesting stuff that may sway them. You could hear something the last day of testimony that could change your opinion with regard to a case. And it happens. And you have to think that the defense has been saving their strongest witnesses for last, because that's the last thing the jury's going to hear before they go to deliberate. And they're going to tie it all together in their closing statement, closing argument, as is the plaintiff. And I don't know. I mean, the closings are supposed to be on Monday, right? But I don't know, based on this latest motion, whether that's going to actually happen. What do you think? What say you, my friends? What say you? Elena Kushner, that was big testimony. Yeah, the thing with Elena Kushner, and I have a copy of her lawsuit and her husband's lawsuit, is, and I don't even know if it was brought out in her testimony, but Elena Kushner and her husband and their child was not admitted to the hospital until 2018. So that was 2 years after this case. So I would have objected to that as saying this should not come in because this is after the fact. I mean, I could see if Elena Kushner's testimony had to do with something that was immediately preceded by the October 2016 admission of Maya to the hospital, but something that happened 2 years after this case happened, in my opinion, may not indicate that she was behaving that way before October of 2016. So that was very odd to me that was allowed in. And it was very, very short, that testimony. So maybe we will take a look at that. And I don't know if they should have allowed it, or if the defense said, sure, let it in. We're going to object to it later because it was 2 years after. Doesn't go to her custom and practice of 2016. Hi, Judy Ron. Thank you so much for your $10 Super Chat listening and driving up to Armonk, New York. Oh, wonderful. I hope you have a great day. It's actually sunny out today. So it wasn't supposed to be. It was supposed to be cloudy. So thank you so much for your support. I appreciate you. Desert Quill, thank you so much for your super chat. $20. Thank you. A friend just recommended your channel in the 70s when I was about 11. I was diagnosed with RSD. Your particular style covering this case has been amazingly informative and cathartic. Oh, thank you so much. Thank you. RSD is reflex sympathetic dystrophy, which is the name by which CRPS used to be known. It was changed to CRPS. Complex regional pain syndrome. Yeah, complex. It is complex. Thank you, Tara, for your super sticker. I appreciate you so much. Hey, Paul. Thanks for your super sticker. Will you address super chat? Will you address subject matter jurisdiction with regard to which issue? Can you just clarify that for me somewhere in the chat? I'm not saying that Elena Kushner didn't matter at all on the stand. What I'm saying is I don't know if they made it clear that what happened to her was in 2018, right? Gary says, but she's testified she has never worn a lab coat even now, except in specific circumstances during COVID. Okay. All right. Hopefully they're going to tie that together for us, Behind the magic. She's only brought in to prove Sally wears a lab coat. Sally Smith, she never did in like 30 years, but all of a sudden started during COVID. Okay. So again, they could disregard her testimony. She said she never wore a white lab coat and didn't own one. It was rebuttal testimony on that point. Okay, good. Then it forward, wasn't it relevant because it was regarding Sally Smith and the same type of situation? Yes, except they didn't get into that. They didn't get into the subject matter of that lawsuit, which is similar. And I have a copy of it and we can go through that another day. So it is similar. False allegations by Sally Smith, just the lab coat testimony that had happened 2 years later. Yeah, I don't even own a lab coat. Again, she may not own one. They may have them in the hospital for doctors to put on and wear during their time in the hospital. So yeah, they may just be there hanging. I don't know. Yes. Yeah, they couldn't get into it because it is very limited, right? More prejudicial than probative. And that Kushner lawsuit, plaintiff is represented by Greg Anderson's firm, and it's being defended by Hunter's firm. So it's the same attorneys. Same attorneys. Hi, Phoenix Rising. Hello, lovely non-cupcake. Hi. The motion to dismiss the juror doesn't seem reasonable, in my opinion. They're literally describing the job of a juror. If a juror is asking questions, not 100% decided. I agree. And I don't think it's going to be granted, but I've been wrong. Not often, but I have been wrong. Okay, dehydrated slime. Again, she said she never wore one for 20 years. Yes. Agree. And that I'm sure they're going to tie it up. I'm sure they're going to tie that up in the closing. And, if the jury believes it, that she was lying, they could disregard all of her testimony. But I think that they've pretty much made up their mind on what they think about Sally Smith already. And I don't know that that is something that is, I don't know, that big of an issue. I don't know. Everyone's thinking it's that big of an issue. I really don't. I think regardless, I think she held herself out as an employee of the hospital regardless. Because, hello, Matt Vaughn. Nice to see you. Spiffy, legal, mumbo, jumbo, talky, dudette. Oh, I like that. Can I make a t-shirt that says that? I'm Elaine Nix. Sally Smith and that lab coat is like Murdoch and his badge and lights. I wouldn't put it past her wearing one as a way to show authority. 100%. 100%. But she also had a badge on that said JHACH, right? And I think regardless of the lab coat, I think the jury thinks that she held herself out as an employee of the hospital. She didn't say who she was. She never, you think that if she came in and said, hi, I'm Dr. Sally Smith. My specialty is CA pediatrics, and I'm here to ask you some questions so that I can report back to DCF about whether or not you're a proper. No, they would never speak to her. She had to get in there. She had to get in there and choose her words very carefully. Yes, New Hampshire woman. And on the stand, she chose her words very carefully too. Thanks. And that's another merch idea. I'll have to go back and find that later. Do I think Sally Smith is deceptive? Yeah. And, and I think that came out during her proffer, which was also kind of a smoking, it was so interesting to me, the way she came in, she testified, and it was like she had like a PR person almost give her an image makeover, right? Her hair was different. She had different clothes on. She came in, she tried to smile, she tried to be really kind during her examination in front of the jury. And the second the jury left, it was like switch flipped. And she got belligerent and she got nasty and she started talking about what her job is and that it's not my job to give all sides of the story. The plaintiffs had the opportunity, or the plaintiffs, the family, because she would never address anyone by name. The mom, the dad, they had their opportunity to get their own experts in before that judge and to, it's not my job to give the other side and to give the other doctor's records. Well, yeah, it kind of is. You know why? Because now you're putting a financial burden on that family to go out and hire an attorney and hire expert witnesses to come in and testify in a DCF juvenile court proceeding. That proceeding caused them to sell their second home to spend, I don't even know how much. Do you guys know? $40,000 in attorney's fees on that case. So yeah, Dr. Smith, it kind of is your job. It kind of is your job when you have medical records that show that there are doctors out there who disagree with you. I disagree with that. And I think that if the jury had seen that, would have been a major problem. A major problem. Jason, I saw this comment. You can't hide that mug though. And I'm like, do I have a mug here? Am I trying to? I'm like, this is the only mug that I have with my Grateful Dead sticker on it. And there's the wheel, and there's some dancing bears. But no, mug. I think you're meaning her face. Yeah. I was confused for a second. So true, Mel. Thank you. Good. This is a great question. Cali Girl 1, can Sally Smith's words during proffer be used in other cases? Her testimony was very damning. Yeah, and it was also under oath. So can Greg Anderson use that in his other cases that he has against the hospital for the same type of case? There's a transcript. It's under oath. It's sworn to. Just because it's not in front of a jury doesn't make it testimony that wouldn't be admissible. It's a great point. She should have been prepped to know that. Hi, Diana, 1979. It is very sus that she found dozens of MVP cases when an expert said they are extremely rare, and child abuse doctors go entire careers never seeing one. Yes, I agree. I agree. Lake Lizard, exactly. What about people who don't have a second home to sell? Yes. What about the guy who spent 300 days in jail until Sally Smith walked back her allegations against that father? What about him? Not everybody can afford to go into a juvenile court to defend themselves against false allegations. And that's why this is scary. It is scary. Hi, Jen. Lawyer, seems to think the juror might be removed. All the other lawyers I've watched think it will be denied. What do I think? I don't think it's going to be granted. But, Peter, listen, I try not to watch any other attorney's take on this before I report to you because I don't want to be influenced by what anybody says. But I think he knows this judge, and I think he's practiced in front of this judge, and he may have better insight into the way this judge is going to rule, but I just don't see it. I think that's reversible error in my opinion. And, you don't know. you don't know what you're going to get. That's a dangerous motion to make, because you may get somebody who's a lot more generous with the checkbook, you know? I don't know. You know, you can't say, it's kind of like saying, we want this jury excused because he's too smart and he's paying attention. And we'd rather have somebody who's just snoring in the corner and is going to go around with what everybody else says in the jury room. So, yes, I do too. Janine, I really dislike when somebody says it's not my job. Yeah. And I think that was rude. And it was condescending. And I think it was not an accurate representation of what her quote job role really is supposed to be. Right. And she's not a doctor. She's a doctor of social work, not a medical doctor. Missy, who are you talking about? I believe she actually is an MD, Sally Smith. She's a pediatrician. Kathy Beatty is, I don't know what Kathy Beatty is. Kathy Beatty's a social worker. I don't think she has a medical degree. All right, let's I want to watch this press conference that Greg Anderson did on the 27th of October. So let's take a look at this, because it seems a lot of you have not seen it. I'm gonna stop it so that you can hear the reporter's questions, because it is they are hard to hear. And how do I make this full screen? One sec.
So, Mr. Anderson, we heard, yesterday from attorneys for Johns Hopkins say, that they want to win this case to show that reporters of medical child abuse can.
Wait a second. Oh man, why do you do that to me? All right, give me one sec. Talk amongst yourselves for a second. All right, I got it. So the volume doesn't want to play. All right.
So, Mr. Anderson, we heard, yesterday from attorneys for Johns Hopkins say, that they want to win this case to show that reporters of medical child abuse can still come forward. We know that is not the case.
That's not the case.
All right, let me just rewind so I can tell you that question. Come on.
So, Mr. Anderson, we heard, yesterday from attorneys for Johns Hopkins.
Mr. Anderson, we heard yesterday from attorneys at Johns Hopkins.
They want to win this case to show that reporters of medical child.
That they want to win this case to show that reporters of medical child abuse can still come forward.
We know that is not the case.
That's not the case. We're here and they're opposing us because of Beata and Jack Kowalski's ability to decide what the best treatment was for their child. We have a situation here where unqualified physicians second-guessed 4 different specialists as to what Maya Kowalski had and the appropriate treatment. And the treatment worked. Johns Hopkins, with physicians that were not specialized in any way, shape, or form, second-guessed Beata Kowalski. And Beata Kowalski stood up for her child and her family, and that was the worst thing she could have done insofar as Johns Hopkins, because she challenged them. She challenged their diagnosis and their treatment. They thought no matter what they said, it was the right thing to do. It wasn't. It was wrong. There's not a single psychologist or psychiatrist in this case, expert, that agrees with their quote diagnosis. Not a single one. There is no treating physician that agrees with their diagnosis that of lack of CRPS or their criticism of the treatments for Maya. So the case is about individual freedom, the freedom of parents to be able to make their own decisions for what is in the best interest of their child based on their own gathering of knowledge and their own requests for information and the advice they received from their physicians. Maya's long-term pediatrician agreed 100% with their decision.
And we've been talking about that a lot too. We've been talking about how this case is shining a light on that. Should parents be allowed to decide their children's medical treatment? And if a hospital like Johns Hopkins disagrees with that medical treatment, should they have the right to go into court and to have a parent's parental rights stripped? That is a very, very scary proposition, especially in Pinellas County, where DCF is privatized. Sally Smith worked for a private firm who didn't get paid unless they were needed, unless they were taking children away. Follow the money. It's accurate. It's the truth. Come for me in the comments. I have merch that says that. Come for me in the comments. Respectfully, debate with me. But that is the problem with a privatized DCF system. They don't make money unless they're needed.
Working with what you just said, now a key here is the issue of over medication. Now, recognizing that she did have that
What's that issue here is the issue of medication. Now, recognizing here that you did have
illness, but the issue here is over medication
illness, but the issue here is over medication
as well.
Talk
a little bit about that.
Tell us a little bit about that.
Considering that they mentioned such alarming amounts of
Considering that they mentioned alarming amounts of pain medication.
They made the claims with a complete and utter lack of knowledge of either the disease or its treatments. Admittedly, the ketamine procedure in Mexico was new, but it had been performed on over 100 patients with no complications or problems. And ketamine has been certified for over 50 years for use in this manner.
And that is true. And if you watched my live stream the other night with Dr. Cave from Medical Secrets YouTube channel, subscribe to him. He's amazing. He's very kind. He treats a lot of chronic pain patients, including CRPS patients with K therapy in San Francisco. It has been approved for 50 years. I think there's a lot of misinformation out there about how that drug can be effective for chronic pain patients, whether you agree with it or not. It can be effective. It has been used for 50 years. This is not a street drug or a club drug that was taken and turned into a pain med. This has been an anesthetic for over 50 years, used in surgery to put people to sleep. So they were using it off label because it's not apparently at the time was not FDA approved for pain medication at the time. I don't know, but it has been out there for 50 years. It's not a new thing.
Johns Hopkins has its own ketamine infusion protocol, which we put before the jury. It happened to differ from our outside physicians' view of what was the appropriate amount. And keep in mind, they started criticizing the Kowalskis before they even checked with any of the experts that had treated her and had recommended that. And one thing that they never, ever explained was why they jumped to this conclusion in the matter of 2 or 3 hours one Friday morning, afternoon, and changed a diagnosis that they themselves had made and was in their records for the preceding year. So then, without checking on any of the people that actually knew what was going on and knew that Maya had been through all of the recommendations that they had, they went ahead and decided that it was the wrong thing, and they had no basis for it. The point is that Maya had been through physical therapy, occupational therapy, psychological CBT therapy. She'd been through all of the therapies that they wanted to put her through and forced her to go through in the stay in the hospital. And it's unbelievable that they did not check to learn that she had already been through all of those treatments at Tampa General. She'd been through that at Lurie's. She'd been through that with private therapists. She'd been through all that. And she'd already been through a course of other medications used. She'd been through a course of opioids, which they did not want her to have that. I'm talking about the Kowalskis, but was the only thing available, they thought, as to pain. And it wasn't until Dr. Anthony Kirkpatrick in Clearwater, who's an expert at it and I guess chairman of the RSD Foundation, diagnosed her, that they even knew about the ketamine. There's absolutely nothing here to indicate that this family in any way, shape, or form was frivolous or lacked the appropriate information before they made the decisions they made.
Up until now, we haven't heard the hospital side. So I have a few questions now that their testimony
Up until now, we haven't heard the hospital side. So I have a few questions about
have raised. The psychological component of this.
testimony your side has raised, the psychological components of.
Can you talk a little bit more about that, and if there was any element of lack of acknowledging that issue?
Can you talk a little bit about that, and if there was any issue with lack of acknowledging it?
Well, if the question is lack of acknowledging the issue, there is no question that somebody who is in the level of pain that CRPS patients are in has some psychological component. That's agreed to by everyone. But that's not the determination of whether there was a psychological disorder. The important thing to consider here is the defense has not been able to get a single psychologist or psychiatrist to show up with a diagnosis of Beata or of Maya Kowalski of a psychological disorder. None. And I challenge them on that as to whether they've got any retained expert out there who's agreeing with them.
How is this on Jack, Kyle, and Maya, especially having to go through the defense?
How is this affecting Jack and Kyle, especially having to go through all this?
It has been horrible. Maya has CRPS lesions appearing. It's not good.
Would there be anything else you'd like to add that we haven't talked to ask?
Would there be anything else you'd like to add that we haven't asked about?
The hospital is trying to portray this as saviors of the child abuse system, and that's simply not the case. That's not what this case is about. It's about the ability, when you've got a government agency aligning with a huge medical organization, to make up their minds about something just because they disagreed with the parents. And in failing to do any of the appropriate investigation and research, just decided that because who they are, they had a right to dictate what happened to Maya, and they were wrong.
Thank you.
Thanks, everyone.
I happen to agree with him there. I think that is the biggest part of the case. What say you? This was on October 27th. So remember, this was before Halloween. They got into some testimony with Maya and some pictures of Maya going out on Halloween and going to homecoming. And they are trying to paint a picture where they are trying to say that her damages are not as great as the plaintiff would like you to believe. So, if you have not seen, I think we need to watch this. We need to watch what they did to Maya on the stand the other day. was day 15. Do you guys remember Maya's testimony on damages? Because that's going to become very important too. And I don't know, because I mean, it was so long ago. I think that was on October 13th when she talked about her testimony on damages. But let's go to day 28, which was the 1st of November, and take a look at that first. I like the way that Law and Crime does this, because they have excellent chapters. And so if you know what day you're looking for, you can go back and just look for the day. And this was day 28, which was just on November 1st. Let's take a look at this. First, they played Maya's depositions, 2 portions of her depositions. Remember, she gave 5 depositions in this case. So I want you to take a look at this. 1 second, let me just find the exact. Okay, 1 sec. Here we go.
Her muscles built up. There's no lesion.
August 20th, 2020, and the second is a March deposition, Maya Kowalski.
I don't see nothing right now.
The defense next calls by deposition, Maya Kowalski.
You hear it?
First deposition is August 20th, 2020, and the second is March 12th, 2022. And I believe they'll run consecutively.
I'm sorry?
They should run consecutively. They're 2 different depositions. The first is, I think it displays on the screen runner, but the first is August 28th, 2020, and the second is March 12th, 2022.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I swear.
Good morning, Maya. How are you doing today?
I'm doing well. How are you?
And so PE was one of your electives in 8th grade?
Yeah.
Did you pick PE this time, or was it picked for you, for lack of a better term?
I picked PE.
And what kind of activities were you participating in PE class in 8th grade?
8th grade, I was participating in everything that all the other students were. So football, any type of sport we did, all the games, and so on.
That's what I was getting at. So you don't recall having any flare-ups in 6th, 7th, or 8th grade?
Correct, no.
Have you had a flare-up since you graduated from 8th grade and you're getting ready to head into high school?
No.
So why don't you do me a favor and walk me through a typical day in Maya Kowalski's life over this summer, let's say, starting with your 4:30 a.m. workout regimen. Walk me through your workouts, what you do for hobbies, who you play with, and all the way through to when you go to bed at night.
I wake up at 4:30. I immediately go on my walk, which lasts normally 1 hour and like an hour and a half to up to an hour and 45 minutes. It just depends on the day. I come inside, I set out my yoga mat and I do some yoga. After I finish my yoga, I take a shower, get ready for the day, eat breakfast, and that's when my day really begins. So I will check my email, take out my dog. I will do the dishes, do the laundry, put away dishes, put away laundry. I will make myself lunch. I will practice piano for an hour. I try to do that every single day just to get in a routine. I really enjoy reading. That's something I love to do. So anytime I have leftover after piano, I like to just relax a little bit. And throughout the day, I'll take out my dog. Obviously, I don't just take her out once, but she doesn't have a schedule in terms of when she has to use the bathroom. And I start winding down at 5 o'clock. I have dinner with my family, and I pray, read some more, and I ultimately go to bed around, I start getting ready around 7, which sounds early, but I wake up at 4:30. So I try to get enough sleep. I don't sleep very well. And I fall asleep 8:30, 9.
So it seems like piano, if you had to rank your hobbies and interests outside of school, is piano right near the top?
Oh yes, piano is number 1.
In terms of your workouts, I know you said you did a little bit of yoga. Do you do the yoga after the workouts? Are those kind of 2 separate workouts, or is yoga part of your 4:30 a.m. workout regimen?
They're 2 separate workouts.
Okay. Walk me through what you do when you work out at 4:30. I just want to get an idea of the type of exercises you're doing, the duration, that kind of thing.
Yes, so I simply go around this circle here, because we live in a community that is circular. I go around that 6 times, so that's 5.5 miles. And I'll do some cardio, so running. I could do some high intensity interval training, so 20 seconds of running, 10 seconds of rest, so on and so forth for however long. And then I mix that in with some power walking, because obviously first thing I cannot run around the circle. I just can't do that at 4:30. So the first 3 laps, I would say, are just me walking and warming up my muscles.
Okay. And what's the when you said you do power walking, what is that?
Power walking, just faster pace walking.
Okay. Do you ever do any weight training in the morning?
I used to, but I switched halfway in the summer. So I used to do very intense cardio, and I absolutely love cardio, but now just waking up even earlier than I was before, it's easier for my body to adjust in the morning by walking first, then implementing cardio.
What about your current medications? I saw from Dr. Wassener's records that Claritin and Flonase are your only 2 medications you're currently taking. Is that accurate, or are you taking additional medications?
That's accurate. I'm just taking the Flonase as needed and Claritin as well, just as needed.
Is it fair to say you haven't had any ketamine or narcotic medication since you were discharged from Johns Hopkins All Children's Hospital in January of 2017?
Yes, I haven't.
You haven't?
I have not, yeah.
Any other doctors that you're seeing outside of Dr. Wassener, or a primary care doctor that works with Dr. Wassener?
I don't think so, no.
Are you seeing a doctor that specializes in pain or CRPS currently?
No.
Do you know the last time you met with a physician who was a pain doctor?
I can't tell you, sorry, no.
Have you had any flare-ups of your RSD or CRPS in, let's say, 2018?
I don't think I did, no.
What about 2019?
No.
And then we call by deposition, a brief deposition of Maya Kowalski, March 12th, 2022.
What year?
Sorry, March 12th, 2022.
Ms. Kowalski, would you be so kind as to raise your right hand? Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Are you in any pain right now?
Right now I'm fine.
Are you on any medicine right now?
I have this one pill and it's for sleeping. I take Claritin, but I can't think of anything else right now, no, other than my acne medication.
You play the piano?
Yes,
So activities, it sounds like you're still doing ice skating.
correct.
Okay. Any other physical activities that you do?
No, I mean, I work out, but no other sports.
Okay. So working out is different for everybody. What kind of things do you do when you work out?
It just depends how I'm feeling that day. I mean, sometimes I lift weights. I like cardio more than anything. Lifting weights isn't really my thing, but I do it periodically. I swim. I like to go on bike rides, and I really like walking.
Fair to say that you're doing better now from a pain standpoint than you were in 2015.
Yeah.
Okay. And is it fair to say that you're doing better from a pain standpoint than you were in 2016?
Yeah.
Your Honor, now we would like to publish what's in evidence, a photograph that's a defense exhibit 3138-2.
Okay.
And we'll publish what's in evidence, defense 3138-5. And we'll publish what's in evidence 3138-7. And we will publish what's in evidence 3404-1. And we will publish what's in evidence as 3404-2. And these will be in evidence. And then, Your Honor, if we may take a short break at this time, and then we'll come back.
Well, I think it's time for our morning break. Members.
Okay, so that was part of the day in court on November 1st, the day after Halloween. There was a Halloween picture that they published in the New York Post that was not either submitted or allowed into evidence to be published to the jury of her in a Halloween costume. So I'm just going to submit to you that if there's any juror who's on the fence about damages, this may have been damaging for the plaintiff's case. We saw the first deposition was in 2020, August of 2020, which remember was during lockdowns. I don't know if they were locked down in Florida, but she testified that she was getting up at 4:30 in the morning, that she was running 5.5 miles a day. She was doing yoga. She was doing piano. I don't recall. Maybe someone can refresh my recollection about whether she's ever testified in the beginning of the case that she never played piano anymore. So in 2020, she was playing piano. She was exercising. She was getting up at 4 in the morning. She was able to run 5.5 miles, which is something that I don't do. And she was in gym and she was on no medications, no prescription medications. The second deposition was in March of 2022, which was 2 years later. And she did testify, admittedly, this was one part of the deposition, who knows how long it was, that she was in no pain, that she was able to ice skate and still work out, and that she still was walking. So they expect her to spend life in bed 24/7. Scott, I think it's only slightly damaging. It doesn't take away from the hospital and Sally Smith's actions. No, and it doesn't. But here's what you need to show in a negligence case, okay? And I remember my torts professor in college, in law school, This is how he would describe it. A negligence case is like a stool. There are 4 legs of the stool. And without one of those legs, it's not my bad impression of 4 legs. Without one of those legs, the case cannot stand. Okay. The first thing is a duty. The defendant had to have owed the plaintiff a duty, a legal duty. So that's why they keep showing this Bill of Rights, right? The patient's Bill of Rights, that the patient is entitled to these things. So I think we can all agree that the hospital had a legal duty to Maya, right? Their second leg of the stool is breach. So there has to be a breach of that duty to the plaintiff. And I think we can all agree there was a breach of that duty by various actions that happened through doctors, Sally Smith, through disregarding the mom, through disregarding the prior diagnosis of CRPS that was in the hospital's computer. The next thing has to be causation. So there has to be causation between that breach of the duty and what caused the 4th leg of the stool, which is damages. So duty, breach, causation, damages. You have to prove they had a duty. I think we have that they breached the duty, and that there was causation, and that there was damages. Okay. So we have to look at what the damages are, and that's where the money award comes in. So if they get through liability and they say, yes, there was a duty, yes, there was a breach, then they decide whether there are damages, what those damages are, whether the hospital, who is the only remaining defendant, caused those damages, and what those damages are worth. So the damages of the case are in the permanency of the injury that the hospital caused, right? So where I think this is going to be sticky, and what I think a lot of people don't understand, yes, the people in this chat agree that she had CRPS. Yes, the people in this chat agree that the hospital owed her a duty and that they disregarded her mom's wishes, and they disregarded her diagnosis of CRPS, even though they billed $500,000 for CRPS. But when we get to the causation, the hospital didn't cause her CRPS, right? Because if the position is she went into the hospital with CRPS, the hospital couldn't have caused it because she already had it, right? So this is where it gets sticky. What are the damages with regard to what happened to her in the hospital? Yes, she doesn't have her mother anymore. Her mother took her own life, but that is a separate 4-legged stool. And we'll get into that in a second. According to these depositions, and if you believe these depositions, which were taken in 2020 and 2022, she's now off all medication. She has no pain. She's able to exercise and do a lot of great things. She's become a great student. We have to talk about 2 elements of damages: the pecuniary loss, which we heard some testimony from in the beginning, from an economist who talked about her potential loss of income in the future, her future loss of income, and that's a tangible pecuniary loss. Medical expenses, or that's a tangible portion of damages. And the psychological damages that were done to her while she was in the hospital. That's why we heard a lot of testimony about how she's afraid to go to the doctor. She's afraid to go to the hospital. She doesn't like to wear, I don't know, you can correct me if I'm wrong, gold jewelry or silver jewelry, because Kathy Beatty only wore one of those types of jewelry. How she has a lot of fears and hesitations and PTSD that's going to carry on throughout her life. But is the jury going to agree that physically she is in a worse condition now and will be for the rest of her life than she was during the 3 months that she was in the hospital? And that is something they may get stuck on, and that's why they showed this testimony. So I'm not saying whether I agree with it or not. I'm saying this is what the jury needs to decide. The second part of this 4-pronged stool is Beata taking her own life. And this, I don't even know if this is still a cause of action in the case. If somebody can point this out to me, the wrongful death cause of action, or if it was withdrawn, but they keep putting evidence in about it. So I'm going to assume that it is, because they showed Beata's notes that she wrote, her emails that she sent before she took her own life. And we're going to look at those as well. But duty, breach, causation, damages. Did the hospital owe a duty to Beata? To Beata. She was not a patient at the hospital. She was a mother of a patient at a hospital. And I've said from the beginning of this case, I thought this was going to be very difficult to show that the hospital caused Beata's taking of her own life, because did they owe a legal duty to Beata? Duty, breach. Did they breach that duty if there was a duty? Did they cause her, did the hospital cause her to take her own life? And I think that we can agree the fourth part of the stool is there, that yes, there are damages to the family because of what happened or because of what Beata's taking of her own life. But can we connect that back to the hospital? And did the hospital owe Beata a duty? If you believe the testimony of Dr. Tepa Sanchez, which we could go back and watch, and I had to find this, I had to dig deep to find this. Dr. Tepa Sanchez testified that Beata told her in the hospital, and listen, I don't know whether I believe this or not, but all it takes is one juror. Remember, they have to be unanimous. That Beata told Dr. Tepa Sanchez that I just want to die. I just want to go away. I want to go to heaven. I can't take this anymore. So there has been some evidence, that isn't the only evidence, that Beata may have gone into this with some ideations or thoughts of taking her own life, whether you believe that or not. It's really whether the jury is going to believe that. So that's just another thing to think about. But what happened that day, November 1st, what day was that? Wednesday? Yeah, Wednesday. Is that this happened. They showed the deposition testimony. Then they showed those photos. And then they had some arguments about other things. And then they called back, the defense rested. They called, the first rebuttal witness was Dr. Chopra. Jury went to lunch. Then they called Jack Kowalski to talk about this feces explosion and how he was cleaning up the feces. I don't think we need to play that. Then they called Dr. Corcoran as a rebuttal witness, who gave the excellent testimony that led to the reports that they're now demanding, and whether or not they had that deposition yesterday is anybody's guess. Then they finally called Maya back later in the day. But they only questioned her. The plaintiff only questioned Maya about the photographs that were taken in the hospital and about whether or not that was Kathy Beatty's hand holding her down. And I thought that it was very interesting that they did not question Maya about these other photographs from homecoming in the limo and the other photographs. And he didn't. And then the defense asked some questions, and that was it. And then they went out on a break. And then they called Maya back to the stand, because Maya must have given Greg Anderson an earful out there in the hall. Like, why didn't you call me in to talk? Why didn't you ask me about those other photographs they showed? She wanted to defend herself about it. So they did call her back again to talk about those photos. So let's take a look at the second time they recalled her. If you want to go back and watch the first rebuttal testimony of Maya, this is called day 28. This is day 28 on law and crime. They've got the good chapters. You can take a look at that. And she talks about, she swears it was Kathy Beatty holding her down, etc. But let's take a look at what Maya said when she came up for the second time after talking to Anderson in the hall. when given an opportunity to defend herself against those photos. And you can see how hurt she was and how she really wanted to explain it. Oh, it just went back to a different time. Hold on one second.
Explain the homecoming pictures.
Take 2 minutes.
Ms. Kowalski wants to explain the homecoming pictures.
Take 2 minutes.
Before we get to that, let's talk about the policies and the Joint Commission issue, if you have any further update.
Yeah, yes, Your Honor. On the last remaining policy they were looking for, my client.
Well, since we're here, we'll listen to what they say about the Joint Commission reports outside the presence of the jury.
If they checked, the older policy was put into an archive system that no longer exists or that they have access to. So I have no more policies to produce. On the Joint Commissions, there was a Joint Commission triannual survey done in, I believe, August 2018 that the hospital passed. The IJ, that they were talking about was related to the Heart Institute that was separate and apart from the triannual survey.
Oh, we're getting this.
Okay.
If he needs it.
What do the plans want to do? Because, look, here's the policy. Does that really matter at this point? And I guess the bigger question is, are you going to press the Joint Commission, or are we?
So, yes. So speaking to the policy first, as long as we can get a stipulation that annual performance reviews were required in the hospital policy, we don't need to see the policy. Alternatively, we adopt the 2018 policy and put that into evidence to solidify that annual reviews are required of their employees.
Right. They were, to disagree, we would have to call a witness. I mean, there's an email that we can move into evidence if they need it. It says specifically, and I can try to put up on the screen, from the director of HR hospital-wide, that for the review period of July 1 to December 31st, they were deferring evaluations. I think this is pretty clear.
Is this part of the deposition that you stopped?
No.
Well, didn't you move for a protective order during the
Not on this
deposition?
issue whatsoever.
Okay.
It was terminated when we tried to ask questions about the policies. So
Judge, they're going to try to imply that we didn't do something that we couldn't do because of the changeover, and that was fully covered in the deposition.
I'm sure you should make that decision.
Again, a central problem I've always had in this case is one side says the light's red, the other side says the light's green.
We have the transcript, Judge, of the deposition.
Sure. Let's put it up. Let's put up the termination of it.
What issue, I guess the defense would ask, what issue is the plaintiffs trying to show that this specific policy would cover? Into what allegation?
Well,
I mean, did they want us to just stipulate? They have all of Kathy Beatty's policies.
There's a period of time that, of course, impacts the exact same period of time of Ms. Kowalski's hospital stay, that the hospital has an explanation for it, and the plaintiff is challenging the explanation. Whether the explanation is correct or not is not really, for me, it's a question of fact for the jury.
That's what I always say. The juries are the finders of fact. The judge will instruct them on the law, but it is up to the jury to determine the facts.
So at the end of the day, though, out of all the issues in the case, is that this issue big enough for us to not rest today. And I really think we probably should be talking about the Joint Commission issue, because if the Joint Commission issue is going to keep the evidence open, that might inform what we're going to do on the policy issue. So that's why I kind of want to deal with the Joint Commission issue.
We would demand, request the Joint Commission triennial survey that was just referenced, and the self-report that was referenced earlier, and any other associated Joint Commission or federal agency findings during that time, because both were referenced in Mr. Anderson's testimony, Mr. Witness Anderson's testimony. And we can set, I don't know if we need the deposition, but we need the documents.
And Judge, if they were left with the idea and the expert's testimony that this hospital was well run and they had been approved, there was a governmental and an industry approval process, and they passed with flying colors. Now, if that was not true, then this is a very serious matter. So we've had difficulty throughout this case getting documents from the defense, and we would really like to see all of those.
Well, look, if it turns out that this is only involving whatever the heart department is called, whatever you're calling it, that's not relevant to this case. If the incident or incidents that cause the finding of imminent jeopardy, and I'm assuming that imminent jeopardy means that loss of accreditation and loss of ability to receive federal funds, if that isn't the specific time period or soon after the specific time period of Ms. Kowalski's, it probably is not relevant. If, however, either of those two is true, that it is more systemic than just the heart department, and the time period overlaps or is very soon after Ms. Kowalski's stay, then the plaintiffs are going to be allowed to investigate and present this information to the jury. So
there you hear the judge's rationale for all of this. And if the hospital was in immediate jeopardy of losing their accreditation, that's what this is about. During the time that Maya was a patient there, or in and around the time that she was a patient there, then it's relevant. If it only related to the heart, the cardiac unit of the hospital, it may not be relevant. That's why we saw this motion. Was it a motion that we saw yesterday? And the motion to seal, or that's why, yeah, there was a motion for a clarification filed by the defense yesterday at or about 4 p.m. That's 178 pages. That is locked and sealed by the court clerk. And we don't know what's in it. And we don't know if the deposition happened. And that's why I think they want the judge to review the documents in camera to see whether or not they are relevant, applicable, and whether or not they should even have to have a witness be deposed about them. So if anybody is on the inside of this, if anybody knows whether that deposition happened, please let me know. If you know for a fact whether it happened. It was supposed to happen yesterday at 4 p.m. This could really prolong this case a bit if this issue sticks. But you see, everybody's working overtime on this during the weekend, after hours. Who knows if they're in there today? I don't think there's any feed today, but they could be in there today going over this, because they've been very meticulous about getting things done on this case, even if they have to stay late and work weekends. And I don't know that the judge will come in on a weekend, but he may be available by phone. I don't know. If they've had a Zoom meeting on this today, I don't know. But I know he is very serious about getting the jury this case as soon as possible, because he knows that some of them have conflicts and they have to leave and they cannot stay on. They've been there since September 21st.
I just, from a factual standpoint, that's why I need to rely on the lawyers, and I can't seem to get a definitive answer.
If we could get those reports and we knew they were the right reports, this whole thing could be over. I don't understand why there isn't a phone call with an operation this big and it's emailed over and we print it out and we look at it and we go, fine. This is neonatal cardiologist. Judge says it's not relevant, not relevant. If it says what we think it says, though, it's a very serious matter. Because there was a duty to retract that representation if counsel knew that that was not true in the actual reports.
Right. If they gave Dr. Mark Anderson a summary of these reports and told Dr. Anderson that there were no issues with the hospital and that everything was great, and they were accredited, there were no outstanding issues with the commission or any of these reports or the CMS reports, and that's what he testified to, it's a problem. And the testimony should be disregarded. And they should be able to just make a phone call and find these policies. It's really not, they're making it out like it's such a burden for them to find this stuff. They've been on this case since Maya was in the hospital in real time. Shapiro and Hunter, this law firm, they were consulted by the hospital before there was even a lawsuit filed in this case. So in my opinion, and I think the judge can see through it too, these arguments are a little disingenuous, like we can't find it, it's hidden away, we put that Dracula to bed or whatever he said. They've been there since day one on this case, and they've been working for the hospital since before this case and ever since. So I don't know that the judge is going to believe that they couldn't find these reports by making a phone call. They're out there. They may even be public. I don't know if anybody knows if they're public and they have a copy of it. Send it over. Oh, it is very public. Thank you. Oh, about that other comment that I just took down. I think that was Dr. Tracy. Yeah, and I agree with you. And why are they focusing on Maya? Why are they not focusing on the speakers? And this is why the judge in the Koberger case ruled that he will allow cameras in the courtroom, but he wants control over what the cameras are focusing on. Because we don't need to see the back of the defendant's head the whole time instead of watching the attorneys who are speaking and the judge. They should never be allowed to show the jury, and they don't. But, I mean, can we give this girl a break? Let's watch what the attorneys are saying. I agree with you. KM Hope says the very public CMS report makes it clear it was system-wide and included the time that Maya was hospitalized. Then it will be relevant, and then it will come in. Thank you, Christina, for pointing that out. Joint Commission is not public. CMS is public. I'm just saying, I thought I buried that Dracula. Yeah, that could be a t-shirt. Kind of like the Heuermann shirt that I showed on one of my streams where it said something like, the pizza is great, but don't forget to finish the crust. And it had a big picture of Rex Heuermann's face, who is the Long Island serial killer, if anybody's not familiar with Rex Heuermann. Yeah, I want to know the possible ramifications for defense lying. Well, listen, if it could be shown that they suborned perjury on behalf of their expert, that's a big problem. If it was an oversight, it could be sanctionable. They could have to pay money sanctions. I don't want to see a mistrial, and I don't want to see that juror replaced because I don't think it would be right. But it's not up to me.
Judge, I have more information, but I don't have documents, and I'm not going to be able to wave a wand over this and get them now within an hour or so. May I respectfully suggest that we be given overnight to produce the documents that Mr. Anderson suggests that he wants? We believe that they will show that the triennial review that we did in fact have after this event was passed and did so handily. We also believe the documents will show that there was a self-report of the Heart Institute issues to CMS, JACO, and the state shortly before January of 2019, and that resulted in the IJ that was then lifted approximately a month and a half later. That is what we believe the documents will show. But I've got to get the documents, and I can't. Unfortunately, I just can't do it on 10-minute breaks. And I not that I don't appreciate being accorded them. It's just that it ain't that quick. So what I would suggest that we try to do, given the hour, I will try to get everything I can in the next hour, half hour, whatever, whatever I need to do. And if the documents aren't enough for the court and or counsel, then I'll do my darndest and I'll find out what we can do to produce someone who can explain and provide a timeline and try to put this whole thing in some kind of context so that we can move on and get this case done. That's what I would suggest.
And I appreciate.
Jesse, Essex, yes. The witness made a claim that there were no issues which created foundation for these documents to now be used in this case. Yeah, it opened the door. It opened the door. And I know that you've been watching some other YouTubers who say that this was intentional and that they've been holding this until the end, the plaintiffs, and that they knew about this. And I'm going to submit to you that they did not, because they would have had Dr. Corcoran testify about that in his initial testimony, in my opinion. And I think that Dr. Corcoran is so enthusiastic about this case, and he feels so strongly about the issues in this case that he went out on his own and looked for these reports. That is my opinion. I don't know that it's right, but I do think that if plaintiff did know about these reports, they would have had Dr. Corcoran testify about them from jump. And the court would have ruled on this issue during plaintiff's case in chief about whether or not these reports were relevant, admissible, and able to be talked about. That's my opinion. You don't play a game like this and then hope they're going to bring it up and then hope that you can come back on rebuttal. No, you got to get it out there. You got to get it out there in the beginning. That's my opinion. And I think, I don't know, Christina, Dr. Corcoran was barred from testifying to this in direct. They tried to get him to testify on the CMS report. They did know it was ruled out till the defense screwed up. Well, then they should have, then why would they have had the Joint Commission reports in the summary for Dr. Anderson? It just doesn't make any sense to me. It doesn't make any sense to me. Oh, wait, somebody had something interesting here. They tried to get it out. They were stopped. Then when Mr. Anderson spoke, they also raised objections. Okay, it wasn't allowable to let Anderson testify. They also tried to elicit testimony about the CMS with Dr. Corcoran. It was objected to. Right, Brittany. I guess you and I missed something because we watched Dr. Corcoran's original testimony on this show, and I don't remember that portion of it. They would have fought to get these documents in from the beginning if they knew about this. All right. Dr. Tracy, I spoke with a JACHO inspector yesterday. He said IJ would be systemic and hospital-wide. All right, well, those records are under seal, so the judge is going to look at it and see if it is going to be able to be shown to the jury and whether or not it will be admissible and whether or not the jury will be able to consider it during their deliberations. Dehydrated slime. Oh my God. You know how much dehydrated slime I have had to try and get out of my carpets? And by the way, it doesn't come out of carpets. So if you have children who like to make slime, is that even still a thing anymore? Because my kids only did that when they were younger. I want to say maybe 10 years ago, they were making homemade slime. And there were always these YouTube channels that would teach them how to make this homemade slime, and it would get in the carpets and never come out. If you have children who like to make slime, don't have carpet. Make sure you have, pergo or floors that are not carpeted, or you will never be able to save your carpet. Just saying. Shapiro said the witness just offered it up generically, like all hospitals have to pass these inspections, blah, blah, blah. That'll be their argument. And it's my opinion that they are pretty damning. Otherwise, they would not be under seal in the courthouse right now. Somebody said, yeah, they have 10 days. And John knows. Hi, John. Because John, hashtag ban slime, was often called upon to try and help me scrape the slime out of the carpet. Thank you, John, for never making slime as a child. I appreciate you. I was my 13-year-olds, they still make slime pickle nets. Oh my God, we digress. Perry, they still do it. Wow. Trishy, 818. Court can testify the definition of IJ is systemic, period. Yes, immediate jeopardy, but I don't think we've established that they were in immediate jeopardy. And I think that's why the judge needs to review those reports, right? And whether immediate jeopardy applied to the, I don't know. It's getting complicated. It's getting complicated, but let's not lose sight of what the real issues in this case are and whether or not the jury gets to consider those reports if they are allowed in, whether the jury will be swayed by those reports. I mean, I think they're showing liability on the part of the hospital without those reports. So let's not lose sight of that.
The not being able to wave them on and get the documents. What I'm hearing though is we can't finish the evidence today. That's what I'm hearing.
If you'll give me some time to run
He's
out
not-
and work the
he's
phone,
not happy
I may
about that.
be able to do better. Here's what my problem is, Judge. I think I can get some of the documents that are at issue here within the next 15 to 30 minutes, maybe a little bit more, but in that ballpark. I despair, however, of the idea that those are going to satisfy counsel. Okay, I mean, we're not talking about, one page here, one page there. We're talking about some fairly beefy documents. So I don't want to tell the court that I can go out and wave a wand to get these things and then bring them back in and have, more backbiting about what they say or don't say. So what I'd like to do is try, and I'll do the best I can to produce everything I can as quickly as I can.
Well, I've got a jury waiting. It's 4:05. I've got directed verdict motions that have to be made. And if we're now postponing directed verdict motions to Monday, that impacts our jury instructions when everything is now waiting on these two issues. And so these two issues, here is what, if we can't resolve it today, this would be a proposal that I would give out. That the plaintiffs by tomorrow morning turn over the documents relative to
The defendants, not the plaintiffs.
when I say this issue, the Joint Commission CMS, the defendants. I apologize. That the Johns Hopkins All Children's Hospital by tomorrow morning turn over all documents relative to leading up to the imminent, what was the buzzwords, the imminent
Jeopardy.
immediate jeopardy. That the All Children's Hospital, if requested by the plaintiffs, will sit for a deposition on Friday on that issue, as well as the policy issue relative to HR. And so that you can have sworn testimony on Friday. That way the parties can get a transcript and give it to whomever you need to give the transcript to, and that we walk in here on Monday morning and finish the evidence. Now, I would also suggest today that we do the DV motions, and we just all agree that we can do the DV motions. And if I have to change a ruling based on the small issue relative to the IG/policy, we can deal with that. But we still proceed with DV motions, and everyone agrees for time purposes, we're going to do it right now. I've got Mr. Elegant on Zoom and Mr. Alton Burns here.
All right. Did we miss Maya's testimony? I thought they called her back. I didn't realize he talked for so long.
Please bring in the jury. And no one approached, no investigation, and received no information. Is that all correct? Correct. And no one approached you about this case. Is that correct? Correct. Did you see any media coverage about this case? Okay. Mr. Anderson, your next witness, please.
We're going to recall Mike Kowalski for just 2 questions. No, you're still under.
Ms. Kowalski, I just want to remind you that you are still under oath.
Yes.
Maya, correct me if I'm wrong, you were a little upset I did not leave you with the opportunity to explain those pictures from homecoming.
Yes.
Please explain to the jury what went on.
So there's 4 things I would like to touch on. So the first thing is that I got my dress the day before homecoming because I wasn't sure if I was going to be able to go. That was dependent on my physical condition and my mental condition. Secondly, I cried for an hour to my dad before that picture was taken because of how bad my leg pain was. I only ended up going was because my boyfriend is the one who paid for the ticket, and I felt too bad to say no. Third thing is that homecoming starts at around 8:30 for my high school. I went there about 9. I got dropped off, and I left before 10. I wasn't able to stay the entire time. Also, I did not post that picture, meaning the defense went as far as to look up my friend's account to get that picture.
Thank you.
How you feel about that? So put your comments in the chat. She's angry. They haven't seen this side of Maya yet. She's very angry. And in fact, she forced Anderson to put her back on the stand. I can't believe he didn't do it. And here she is. Yeah, Sarah, right. That was a little gaslighting, right? I'm sorry you feel that way. Okay, listen.
I apologize that you feel that way. I did not go into your account. Those pictures were emailed to me by several people.
Okay. So then he gaslights her even further by saying, I didn't go into your friend's account. Several people emailed me those photos. So now he's even increasing her PTSD by saying that there are people out there that are snitching on you, that are working with us, that are investigating you behind your back, that are sending me these photographs.
Who wanted the defense to know about them, but
Let's get to rewind that a second.
I wasn't able to stay the entire time. Also, I did not post that picture, meaning the defense went as far as to look up my friend's account to get that picture.
Thank you.
Maya, I apologize that you feel that way. I did not go into your account. Those pictures were emailed to me by several people who wanted the defense to know about them. But while we're on the subject, you did go out for Halloween with your friends as well, did you not?
Several people who wanted the defense to know about them. There are people out there who want to see you lose this case. And there are people out there who don't like you. And there are people out there who are working with us. Yeah, didn't somebody say that his wife was in some sort of like Maya group and she was out there speaking out about this case, Lacey Ann? I'd almost bet his wife got those pictures. Yes, no, Jason, and I'm going to agree with you on this, that it's terrible, but legally it's fair game, unfortunately. And I'm going to go a step further on this with you based on his next questions. So thank you for reminding me where I'm going with this.
We wanted the defense to know about them, but while we're on the subject, you did go out for Halloween with your friends as well, did you not?
I did.
Where did you go?
I went to a friend's house.
Did you go out in public?
Sorry.
Were you out like in public?
Yes.
Downtown Venice?
No.
How late were you out?
I think I went out at around, I want to say like 9, and I got back a couple hours later.
Around 11 p.m.?
Yeah.
Okay. Homecoming, when was homecoming?
It was, I think, about 2 weeks ago.
And when were you out for Halloween? Was that this past weekend?
Yes.
And there's been other times you've been able to get together with your friends during the trial as well.
True. But for limited amounts of time, and it's dependent on my condition.
One moment. Thank you for your time.
He's taking notes. He's got dates and times. And I'm going to tell you that, like it or not, they are probably having her surveilled by a private investigator, because defendants do this in lawsuits and civil cases all the time. All the time. They do it in workers' comp cases too, because if you are trying to get a workers' comp award and you testify that you can't take out the garbage anymore because of your disability, they'll get a private investigator to go sit outside your house and get some video of you taking the garbage out. And this happens in every single case. See how he knew, around 11 p.m.? Oh, how did he know all that? Because they have a private investigator following her. I bet. If he had other photographs, he would have shown them, right? He was waiting to catch her in a lie so that he could impeach her, so that if she gave a different answer. But that was really, really an odd line of questioning. Did you go to downtown Venice? Did you get back around 11 o'clock? Did you go out? Because he wanted her to say no. And then he would have tried to impeach her some other way. So very interesting. Let's go back and see what the jury has to say to her, or the questions they have for her.
Mr. Anderson?
Nothing further, Your Honor.
Members of the jury, any questions? Okay, seeing none, Ms. Kowalski, you can go ahead and have a seat.
Thank you.
I see the transfer. Just a second, please.
All right, so they had no questions for her. That's interesting. What do you think? Why do you think Anderson didn't ask her any questions on rebuttal, on the direct rebuttal testimony about those pictures? About her being able to sometimes socialize with her friends when she's feeling up to it. About the homecoming. About the fact that she only went there for an hour or so. Yeah, she's a teenager. All about the shade. She's a teenager. All about the shade also says, I have chronic pain, but I still feel like I like to see friends. So I usually show up to events, even for a little bit, no matter how I feel. Yeah. I mean, why try and even be more isolated? C. Taylor, I did not go into your account, possibly true, but several members of our defense side did go looking for them and sent them to me. Probably also true. It may have been just people out there. There are a lot of trolls out there, you guys. You know this. You know this. You know this from watching the Richard Allen case, that there was a troll inside the defense firm who took those scene photos, those horrific crime scene photos, and disseminated them to a bunch of YouTubers. Like, there are people out there who do this. They thrive on this. That's what they do. Yes, Janelle, you can't get anything off Facebook. And yes, my sister was surveilled when getting disability. Yep. Insurance companies don't want to pay, you guys. Insurance companies will pay any amount of money to defend a case so that they don't have to pay you or the plaintiff. They don't want to pay. That's not how they make money. They make money by saving their money, by investing their money. They do not make money by paying out on claims. And they would rather pay tons and tons of money to defend a claim than to pay a claim. So it's just a fact. Come for me again in the comments. If you work for an insurance company, come for me. But that is a fact. There are hard trolls. Yes, there are people who are vicious, especially on this case, especially in the chats of Law and Crime, Court TV. If any of you have watched Tampa 13, we've talked about this a lot. They are vicious. They have lots of lawyers for a reason. Yes, they do. Dr. Tracy, I think the Maya pictures and questions about Halloween made defense look even worse. Yeah, I mean, yeah, it depends on your point of view. It depends on who's sitting on the jury. I mean, we know they don't like juror number 1. But we don't know a lot about the other 5. I mean, we know there's maybe 1 or 2 who have had some very thoughtful questions. It needs to be unanimous, you guys. Workers' comp definitely follows people. Yes. Christina, I may have yelled at some of these trolls on Twitter. I know. I don't even go on Twitter. I never understood it. I'm like, what could I possibly say in, 140 characters that anybody's going to care about? I just never understood it. Although I do go there for breaking news because that's the best place to find breaking news. And I go there when I'm angry about something just to see if anybody else is angry about it. Like when Delta changed their loyalty program, I was so mad about it. I had to go and find out if anybody else was mad about it. And they were. So you can also often get validated on Twitter, but it can also be a toxic place as well. Hi, the cat lady. It's interesting that after the IJ info came out, it's been crickets from the people criticizing Maya Ambiata. Has it? Or just because we really haven't seen any coverage and there hasn't been any live streams since then? I don't know. Christina, I try to stay away, but I was angry about the blank shaming of Maya that was happening by Court TV. Oh, Scott, you're banned from Twitter on 3 accounts. Elon won't allow me back. Oh my goodness. Really? What were you doing? What were you doing? Desert Quill, when pain is your existence, you have to pick and choose where to push your pain threshold. I will dance with friends sometimes. Doesn't mean it doesn't hurt. Doesn't mean I won't pay it for later. Yeah, and that's why they could only find 2 5-minute clips of her deposition where she said, I'm not in pain, I'm not on any medications. But we've discussed this before, and there are a lot of viewers in the chat who have CRPS who will tell you that it is a lifelong disease, that it waxes and wanes. You have good days and bad days, and it is a condition that she will have for the rest of her life. And I think that when Anderson came out and said that, she hadn't been in court for a couple of days, and he said her lesions are coming back. This is very stressful. And you can see day to day how some days she looks more refreshed than others. And some other days she looks really, really sick and tired. And it's the nature of the disease. She's going to have it forever. Yeah, Melanie Smith. It must be frustrating for them. FBI is following her around, and all they come up with is homecoming pictures and Halloween. Yeah, and the Halloween pictures didn't come in. I mean, I could show it. It's on the New York Post. But I don't want to. It's it's like a picture of her, kind of like she's wearing a bikini top and a little tiny skirt, like a sarong, and she's in between 2 friends, and they have their arms around her, and she's smiling. She looks beautiful, but yeah, they are kind of slut shaming her, which is disappointing. And so therefore I'm not going to show it. But if you want to find it, you can go to the New York Post, or you can go to, I think the Daily Mail has them too. And I think that if she is being surveilled, why don't they have any footage of her jogging yesterday 5 miles? They should have that, No, I'm not going to show it. Dehydrated slime is back. There's a big difference between going out for an hour versus sitting in court for 8. Also, she was still coming to court for a couple hours at the time she was. And I am willing to bet that there are the people on the jury who do have chronic pain, or who know people who have chronic pain, or who have family members with chronic pain. And they know what it's like. You can't sit for a long time. You can't stand for a long time. Some days you can walk. Some days you can't. Some days, I don't know. Hi, Jay. Thanks for joining. New here. I never heard of your channel. Is the Law Tube thing clicky? I feel like, why wouldn't I have heard about you otherwise? I don't know. I just started this channel at the end of June. So I just started posting videos. Before that, I was guest hosting on Duty Ron and Police Off the Cuff, which are two true crime channels that are hosted by retired NYPD detectives. So I started posting my own stuff at the end of June, and I've grown quickly to over 15,000 subscribers. So we're small, but we're growing. So if you didn't hear about me until now, thanks. Is it clicky? I don't know. I feel like there are not a lot of women out there doing the LawTube thing. I feel like, I don't know, are the guys clicky? I mean, there's a group of like 4 guys that get together all the time. I did reach out to one of them to see if he wanted to do a thing with me because I have the civil litigation experience. I handled cases like this for 30 years, and he has the family law experience, but I didn't hear back from him. He's kind of busy, I guess, but talks about it with other guys. So I don't know. I don't know. You know, Emily Baker is the only other woman I know who does this, and she's probably young enough to be my daughter. So thanks for coming and thanks for watching. And we're getting there. We are getting there. Yeah, Natalie, right? Natalie's out there. I don't know who the other ones are, but there are a few. Thank you. Thank you for finding me. Thank you very much. Yeah, maybe the girls should team up and do like a girl thing, you know? So, you know, go on their channels and suggest me because everyone here is in my chat mentioning other creators. So do you go into their chats and mention me? I don't know. Maybe you wouldn't have heard of me otherwise. But I know the recovery addict has mentioned me a couple of times, and sometimes I go into his chat. But you know, it's hard for me to do other people's shows when I do my own. Yeah, we should do a girls' channel. Oh, you want to go back to law school? Oh, you want to go to law school? Oh, well, God bless you. It's hard. It's 3 years of reading. But yeah, 30 years. Oh, I can't. You don't look like you're, oh, thank you. Thank you. It's a good ring light here, and I have some light from here. But yeah, no, I've been an attorney for 30 years in New York, state and federal courts. I am a mother of 5. So I don't only bring to you the legal perspective, but also the mother perspective. And I am also a working actor. And so that's what happened. That's what happened after the writers went on strike in May. I had nothing to do. So I started just creating my own content at the end of June. And that's kind of how this happy accident happened. So here we are. I will mention it to Natalie. I'm a mod for, oh, thanks, Len. Thanks for your super sticker. Somebody said, can we watch the Shapiro talking to the, let me see if I can find that. It's on Court TV. It's probably on this same page that I have up here. Let's see. Sarah, I looked at the Tampa Bay News. I could not find that the report that you were referencing. So if you want to email it to me, I'll take a look at it, but I couldn't find it. Does anybody have the Shapiro video? If you have it accessible, can you email it to me at fanbase@mlittlelaw.com? Fanbase@mlittlelaw.com, because I'm not finding it here on this Court TV page. Although I'm looking, but let's go back to the chat for a second. Let's go back to Tara, thank you so much for your super sticker. I appreciate you. This is a volunteer job, you know. It's a volunteer job, and my mods are volunteers also, and they are the best on YouTube. I will tell you, the mods make this a great place. They keep the chat classy, and they make it a safe place for people to come and watch this coverage. So thank you, Desert Quill, for becoming a YouTube member. I just literally opened memberships maybe 3 weeks ago. We're going to have a members only live coming up very soon. So if you would like to join, you're not required to join. It's free to subscribe. If you just want to subscribe, hit the subscribe button below and hit the bell so that you'll know when I go live. And when I upload new videos, I usually go live because I hate editing. It takes me so long to record and edit a video, and then it takes so long to upload it to YouTube because it's a very slow process that I would rather just come on here. And sometimes I do it last minute and just come on if I'm, passionate enough about something to want to talk about it. Thank you, Icy Flowers, for becoming a member. I appreciate you. KM Hope for the super sticker. Thank you so much. Night Owl, thank you for becoming a member. I see you in here a lot lately, so thanks. Oh, John, thanks for becoming a YouTube member. That's my son. Lynn, I did address that, and also Moonlight View. Thank you for becoming a member. And Sarah Adams says, and I put this up before, but yes, it is called the S disease for a reason. Sorry, guys, it's like one of the 7 dirty words you can't say on YouTube or they demonetize you. And then I don't care about the money that I'm getting from the views on this case. I really don't, because these topics are so important to me, and I talk about the tough topics. But what happens if they demonetize you is it doesn't get pushed out. So nobody sees it. The only people that see it are my subscribers. And that would be a travesty if nobody sees this. And maybe that's why the last viewer whose comment I pinned up here hasn't heard of me, because these are not getting pushed out because we say things that we shouldn't say. It's like George Carlin's 7 dirty words you can't say on TV. Well, there's like probably 20 dirty words you can't say on YouTube because they think if you say the word, you're promoting it. If you say that S word, that you're promoting that people go and do this. Both patients and caregivers have a high likelihood of committing it with this diagnosis. Yeah, you are correct. But again, getting back to Beata, did the hospital owe her a legal duty? Did they breach that duty? And did that cause her to take her own life? And did that cause damages? Obviously, it caused damages, but there has to be a connection there. And if there's any other lawyers here in the chat right now and you want to give me, thanks, Jen, for joining. I appreciate you. Your thoughts on that? I have said from the beginning, I thought this was a tenuous, the unaliving was a tenuous claim. So we're going to have to see. Miss Donna Marie is back. Yes, Melanie's little cupcakes. I have a sign over here. It's pink. It's hard to read. It says, "You cannot make everyone happy. You are not a cupcake." That's why my logo says, "I am not a cupcake. I will not make everyone happy with my opinions, with my streams, with my coverage. I am a lawyer." Yes, I'm a lawyer. Doesn't mean I have to be neutral. And my opinions will shift based on the case. Sometimes I'm for the plaintiff. Sometimes I'm for the defense. Sometimes I'm for the prosecution. Sometimes I'm for the defense. But I'm always a constitutionalist. And I believe in the Constitution. I believe it should be followed. And I believe in procedure. And I believe that procedure should be followed. And I believe that the rules of evidence should be followed. And I believe that everybody deserves a fair trial. Oh, thank you, Sarah. Sarah says, "You got mail." Let's check the mail. All right. Well, we're here, so let's pull it up. Thank you, Sarah. Somebody else emailed me that it was amazing, and he is a medical writer, and he said, "If you ever need a volunteer to do medical research for you, I love your channel, and I would love to do medical research for you." And I thought, that's amazing. This thing is glitching. Hold on. What's the date of this? Okay, so this was published in February 2019. Oh, Sarah, good get. Thank you. Somebody said I've gotten into lots of trouble for not being a cupcake. I know. Listen, I can't make everybody happy. But if you join the channel, we are little cupcakes because we can make each other happy. And we understand what it's like to not be a cupcake. And you can't always, make everybody happy all the time. And I have 5 kids. There's never everybody happy at the same time. So, you do what you can. And you can't do more than that. All right. Big shout out to Sarah Adams for pointing us to this article in the Tampa Bay Times that was published on February 22nd of 2019. entitled New Federal Report. Remember, this was 2019, so this was new. In 2019, new federal report details widespread problems at all children's hospital. The hospital is no longer in danger of losing public funding, but a 49-page report is damning. Let's see how long this says. Wow, this is interesting. I think we might have just found those documents that are sealed in the court. I will link this article below so that you can read it at your leisure, because it's hard for me to digest it, having just pulled it up. But let's just look at some of the bullet points. A federal investigation into Johns Hopkins All Children's Hospital in St. Petersburg found failures in oversight that went far beyond the hospital's Heart Institute. A report released Friday criticized the hospital's management structure, where virtually all authority rested with a few executives, and rebuked the board of trustees for not exercising proper oversight. It also detailed systemic problems with infection control. All Children's have been required to submit a plan for correcting the issues earlier this month. On Friday, All Children's said the federal government had accepted its plan, found that most of the most serious problems had been addressed, and lifted a threat to withhold public funding. Hospital leaders called the development good news, but said it was by no means the end of this important process. We take the issues raised by our regulators very seriously and will continue to collaborate closely with them as we implement our plan, the hospital said in a statement. We must be vigilant and diligent every day, and most importantly, we cannot forget what happened here and what we have learned. Federal report comes 3 months after a Tampa Bay Times investigation uncovered a series of problems in the hospital's heart surgery unit, where the infection rate had spiked and the death rate had become the highest in the state. The federal review took a broader look at the hospital. Inspectors determined that the board of trustees had failed to oversee infection control, physician competence, and systems intended to improve quality. During a town hall meeting for employees earlier this month, Johns Hopkins Health System President Kevin Sowers said hospital leaders had been aware of safety issues but did not elevate them in appropriate ways to the board. The review also found that All Children's did not track individual doctors' outcomes and had no system for analyzing data used to monitor the overall quality of care and patient safety. Well, I think we've seen a lot of testimony about that, regardless of this report, right? But this report kind of solidifies it. Instead, individual departments were responsible for analyzing their data and communicating problems to the Patient Safety Committee. Hospital employees knew about troubling deaths, but, quote, the facility continued to implement ineffective strategies to ensure safe care, the report found. In the heart unit in particular, surgical site infections increased in 2017 and 2018, but when the hospital offered additional training on the topic in March 2018, none of the surgeons who were having problems attended. Other departments saw an increase in infectious and hand washing fell off in 2018, according to the report. Inspectors determined the hospital failed to provide a sanitary environment and identity, investigate, and prevent potential transmission of infections associated with environmental sources. All Children's also was cited for smaller infractions, such as failing to properly keep medical records, failing to properly document consent for procedures, and not securing oxygen cylinders to their cars. Well, we've seen that, right? We've seen hospital witnesses come in and testify about Maya screaming profanities, but nobody ever documented it. We've heard their excuses for why they didn't document it, and that's just one example. Failing to properly document consent for procedures. There's some question about whether or not she was, her parents consented to her being surreptitiously videotaped in her room for 48 hours in the room that they moved her to. And whether that blanket consent that they signed in a stack of papers during her admission was covered that, which I don't think it did. Okay, oxygen tanks being secured. All right, federal and state regulators visited the hospital in January. That had been January of 2019. after the federal government placed all children in immediate jeopardy, a rare status that requires hospitals to fix issues within weeks to keep their public funding. Only 3 hospitals across the country lost their funding last fiscal year. A spokeswoman for the U.S. Centers for Medicare and Medicaid, so that's CMS, said that the federal government would continue monitoring all children's progress. In addition to the federal regulators, the Joint Commission conducted a recent site visit. The Independent Hospital Accreditation Organization, quote, reported no findings, and All Children's spokeswoman said, yeah, because we can trust the people from All Children's to, accurately report. In an email to the Times, All Children's Board of Trustees Chairwoman Sandra Diamond said she was pleased the hospital's plan to correct its problems had been accepted. She acknowledged there had already been significant changes in leadership, systems, and processes that supported more transparent governance and oversight of quality and safety. Quote, the board has complete confidence in current leadership and the recent efforts towards greater transparency, end quote, she said. But U.S. Representative Charlie Crist, who called for a federal investigation of All Children's after the Times investigation, said it would take a concerted years-long effort to rebuild the community's trust in this institution. For the families impacted, those wounds may never heal, and the hospital needs to be held accountable, he said. Okay, so here are some key findings from the 49-page report. The first one, the hospital's board of trustees failed to protect patients. The board did not properly oversee patient safety in areas like quality of care, medical staff, credentialing, and infection control. It hadn't looked at survival data related to organ donors since January of 2017, though it's required to every year. Number 2, the hospital did not track how well doctors were performing. A senior director told inspectors the hospital did not collect, track, or trend any data for individual physicians. Well, we also saw that in the performance reviews, because they can't seem to find a performance review for that 1 year of Kathy Beatty, and they say that it is missing, or they never did it, or my dog ate my homework, basically. The hospital, All Children's had widespread problems with communication. There was no evidence of any lines of communication and accountability between risk management and any of the 17 committees, councils, and departments shown on the organizational chart as being responsible for the prioritization, development, and deployment of clinical guidelines. Yeah, and we saw that in Dr. Napolitano's testimony, who was the doctor who was on the risk management committee. He was also, I think the chair of pediatrics, and he said that he did not even learn about the Maya Kowalski case until he read about it in USA Today in March or April of 2023. So there was no real-time management by the risk management committee in 2016 when Maya was in the hospital. The risk management committee meetings were only held, I think, quarterly, if that. Most people didn't even show up for those meetings. So there was no way for risk to know what was going on in real time. But who did know what was going on in real time? The attorneys, Hunter and Shapiro. So that's a problem. In my opinion, that's one of the biggest problems in this case. The Heart Institute, so that's about the Heart Institute. There were systemic failures in preventing infections. 9 out of 10 inspected oxygen tanks were unsecured. Several wheelchairs and toys were dirty. They say that corrective measures had already been put in place for each of these findings. And here's the entire report. If you'd like to read it, I will link this article below so that you can read it. Let me come back to the chat for a moment. So we need to see what period of time this covered, which was not really evident from reading that article. That article was in February 2019, but I'm sure it went back to 2016. But again, we'll see. Yeah, damning, Sarah. Thank you. Thanks for sharing that. Jean, can that cause Hunter and Shapiro to have a conflict? I questioned that at the beginning of this trial. And I'm going to say no, because they are the attorneys for the hospital, so they are involved in real time. If they were going to be a witness in this trial, that could be a conflict, but we haven't seen that yet. It was 3 years retroactive, so it went back to 2016. Yeah. Hi, Watcher. Doesn't this prove that Hunter lied to the judge about being just the heart center? I think so. I think so. Lynn, despite them documenting that risk management was authorizing Maya's treatment. Yeah. Yeah, and authorizing them to take the pictures, right? Didn't we hear a lot of testimony that said that risk management was the one who made them take the pictures? Hi, Victorine. Thanks for helping us to understand. It must be a busy weekend for all involved with this trial. Yeah, these guys are not sleeping. Cat lady. Report also said they didn't self-report. Total lie. Yep. Perry. Hi, Perry. Interesting that they want to micromanage patients and families' lives whilst the hospital has serious problems with risk to patients and sanitation. Yep. She was not playing piano after her mom died. Yeah. Emotional support paintbrush. Did you see the judge ask for all emails in the last 72 hours? I think that is where the good info is, but they will probably claim lawyer-client privilege. Whose emails? Emails between the lawyers and the hospital? Those could be privileged, yeah. Or emails that took place during the time period that this report was issued or came out. Any communications between the attorney and the clients are privileged. So we'll see how they're going to get around that. Debbie Jo A, the Keurig is working overtime for these people. I think they got a whole like industrial size coffee pot, you know, like the kind you see in a restaurant where they have like a giant urn. If they're going on Keurig, they're all gonna be standing in line waiting to make a cup of coffee. They all just better agree on one variety of coffee instead of the flavored coffees and just have a big giant vat of coffee. All right, I got another email. You guys are on it. Let's see. Let us see. All right. Johns Hopkins All Children's Hospital made a statement. So hang on for this, because this is interesting. And this came out after this article came out. Thank you to Melaine for sending this to me. Isn't this fun how we all work together and hang out together on a Saturday? Even if you're missing some college football, my game doesn't come on until at least 10 p.m. So that's where I will be then. Okay, this is from Fox 13. Fallout continues from All Children's Federal Report. I'll scroll through this slowly so you can come back and read it later. But we'll just go to the bottom where there is a statement by the hospital. There were 7 immediate jeopardy citations issued to Florida hospitals in the 2018 fiscal year. An immediate jeopardy citation is rare. Federal health officials with the CMS notified the hospital this week that its Medicare contract will be terminated February 23rd. All right, we have to go back up and read this. Experts weighed in Monday on the damning federal report about Johns Hopkins All Children's Hospital in St. Petersburg, Florida, where investigators found problems that represent immediate jeopardy to patient health and safety, so that it wasn't an IJ report, immediate jeopardy. The findings put the hospital in danger of losing its Medicare funding. Here's an expert, Jay Wolfson, said when they went in and did their deep down analysis, they determined that circumstances were so bad that they were placing Johns Hopkins All Children's Hospital in this very rare category of basically extremely dangerous. Explained Jay Wolfson, the Associate Vice President at USF Health and one of the state's foremost experts in the field. Federal health officials with the CMS notified the hospital this week that its Medicare contract will be terminated February 23rd. Talks about the deficiencies in 4 areas that they found. Specific details were not made public, but we just saw the report, so it is. We did find it, unless there's something else that was not made public. The hospital can avoid termination by developing a plan of correction for each deficiency, which must be submitted by February 10th. The stain on the hospital's reputation is something that's so difficult to come out from under, said Wolfson, who believes the problems began when Hopkins took over in 2011. I think they should call Jay Wolfson in as an expert on this case. Why did they not hire him? The plaintiffs. Maybe they're on the phone with him right now. Like, hey, can you come in? We need you as a rebuttal witness. This may be a great opportunity for Johns Hopkins to reach out more aggressively to some of the entities and individuals that it pushed away beginning in 2011. The community physicians, the physicians and researchers at the University of South Florida, the other children's hospitals in the community, Tampa General Hospital, to create a truly collaborative community-based system for providing the highest quality of care for children. This threatens that right now. Here is the full statement from Johns Hopkins All Children's Hospital that was released in February of 2019. The interim VP of Marketing and Communications. Okay, here's the statement from our PR person. I will read this portion to you. Last month, surveyors from the Agency for Healthcare Administration, the AHCA, and the Centers for Medicare and Medicaid Services, CMS, conducted an extensive review of Johns Hopkins All Children's Hospital. In the weeks since their visit, we have developed and are actively implementing a comprehensive action plan to address areas that were identified by the surveyors as needing corrective action. Yesterday, we received the results of their survey, which included citations for issues they identified as deficient. As a result of these citations, Johns Hopkins All Children's Hospital has received a finding of immediate jeopardy. They knew. They knew. Immediate jeopardy is a situation that requires an immediate response to avoid threats to the regulatory or accreditation status of the hospital. We take these findings seriously and are continuing to work in close coordination and consultation with both AHCA and CMS to immediately address their concerns. The safety of our patients is our top priority. We are confident that the work we are doing to ensure that our hospital continues to meet the highest standards of care will satisfy any concerns that they, our patients, or our community may have. Every day we deliver world-class care to our patients and will continue to do so with distinction and compassion. Again, this article is dated February 5th of 2019. Okay, so there you have it. And thank you to 2 of my amazing viewers for sending me that information so that I didn't have to spend all this time looking for it to show you. And Jesse says, and yet they continued business as usual in the PICU. After this report, after 2019, because remember, this case was in 2016 to 2017. How can they, Jennifer Kornman says, how can they stand there and lie to the judge and not get in trouble? Remains to be seen. It remains to be seen. Zero, you can go back and read the report. It is linked in the first article that I showed. If you didn't see it, rewind. And this is very interesting news. And that's why we know now that it is all under seal in the court file. We can't access it. Awesome viewers. We do have awesome viewers here. You guys are the best. Look at this. We've already been on here for 3 hours. We're still having fun. We're still interactive. We're still talking about it. And everybody gets to share what they know and their opinions. And that's why this is such a great channel. Wow, says Noni Lady. Can't believe y'all found this. Thanks to all. Yes, you guys are really up on your research. really up on your research. And remember, the jury didn't hear any of these discussions. These were all held outside the presence of the jury. So they don't know. Yes, Lynn, exactly. Hunter told the judge that it was virtually exclusive to the Heart Center. Well, he better come in with some cloves of garlic on a necklace around his neck to keep Dracula away from him on Monday, because it's going to be, he's having nightmares about this right now. You know he is. And also notice he was conveniently not in court one day. I think he was not in court the day that Anderson testified. Am I right about that? Yes, Sarah, teamwork is the way to go. Teamwork makes the dream work. Wasn't that from Teamwork Makes the Dream Work? Was that little kids cartoon that my kids used to watch? Something Pets. Can't think of it right now. My mind is a blank. Thank you, Vesper. It's a great channel. Love the discussions here. So many vital topics, all the tough topics. Yes. We talked about Matthew Perry the other night, and we talked about the pain of loving an alcoholic. That stream was demonetized before I even put it up, but we talked about it. And I had a therapist on, Meredith Beardmore, who wrote a book, a self-help book for spouses, family members of alcoholics and addicts, and how to handle that, because nobody ever talks about the ripple effects on the family and the pain of loving an addict or an alcoholic. And that was a great stream. And you know what? It was very, we didn't have a lot of viewers, and it's been demonetized, so it's obviously not getting out there. But these are important topics that need to be talked about. You know, and Matthew Perry turned it around. He was sober. And his whole life was consumed by this addiction. And he never was married. He never had children. You know, we talked about this the other night. You know, nothing was ever going to be as important to him as his next drink. And it was a hard conversation to have. And we talked about it. And we had so many people in the chat and in the comments. Go back and read, go for the comments. Heartbreaking. How many people have been affected by this? And how many people are in recovery and who overcame it, but lost so many things along the way. You know, and he finally turned it around. He was finally sober. He opened a sober house. He turned one of his homes, or his home, into a sober home for people who are in recovery to come and live at, to assist in their recovery. That's how big of a heart Matthew Perry had. And we all felt like we lost a friend. We did. We lost a friend. And we talked about it and we cried about it. And that was yes, Jason, thank you. It was cathartic. I thought so too. So, yeah, we talk about the tough topics. We talk about CA, we talk about child CA, and something else that I want to bring to your attention, in case you didn't know, Florida has enacted a law that defendants who are convicted of CSA of a child under the age of 12 are eligible for the death penalty. It's the first state in the country to do it. They've done it. It's not getting a lot of press, but anybody who knows about CSA, and if you know me and you've been watching my channel, you know that I handled the cases against the Catholic Church on behalf of at least 50 or 60 survivors of CSA by clergy back when the Catholic Church scandal broke in 2002. Those cases went on for 15 years, and they were all thrown out based on statute of limitations in New York, because in New York, the law was that if you could keep a survivor of CSA quiet long enough, you would never go to jail and you could never be prosecuted. And it was a 15-year fight to get them to change the law in New York, and it was finally changed. So anybody who's been a survivor or knows a survivor knows that that affects you for the rest of your life, and the damage can never be undone. Very, very few survivors come out of that experience and are able to turn that around. So whether you like Ron DeSantis or not, he took the bull by the horns, and that law is on the books in Florida. So I don't know how many of you were aware of that, but I was going to do a show on that. That's the next thing I want to do. Thank you, Laura, so much for your super sticker. It's just that so many things are coming up. Rodney Harrison, who is the police commissioner out here in Suffolk County, has resigned. I did a show. When I came off that show I did the other night with you guys, and I even forget what show that was. Oh, that was a show with Dr. Cave. The second I came off the live, Duty Ron texted me and told me that Rodney Harrison had just tendered his resignation. So I went on live with him for another 2 hours. Go back and check that show if you like. He is the police commissioner out here in Suffolk County, New York, who has been spearheading the Long Island Serial Killer Task Force. And that is a huge blow to Suffolk County. Huge blow. He tendered his resignation. His last day was Friday, and he is done. And we have yet to hear, I think, a statement from Steve Ballone on this. I haven't seen it. If you guys have seen it, thank you, Sarah, for your super sticker. Thinking that I wouldn't see it unless you threw some money into the pot. Thank you very much. That will go to my children's Chipotle dinner fund. Christina, thank you for becoming a member. And Cynthia Main, thank you for gifting a membership. That's so kind of you. If you guys want to be gifted memberships, there's some way you have to do it. You have to click at the top of the chat, I think, and opt in. And then when somebody gifts a membership, it's random. It kind of just goes out there. I don't know what the algorithm is on that. Because if I knew the algorithms on YouTube, I would, Lynn, give you a member. Thank you. And Natasha, I don't know if I thanked you for your super sticker. Thank you so much. Maya gets a cake and to eat it too. Thank you, Sarah. Again, you're being very generous today. Is there anybody else here that I forgot? See if there are any pressing questions here. We've been in here for 3 hours and 15 minutes. Perry, people who commit those crimes should fear a knock on the door from police for the rest of their lives. Yeah. Or from a dad. Yeah. Yes, Lynn. The gifted memberships usually go to people who are participating in the chat. Yes, so feel free to participate. Just, be kind. Be kind. Okay, Jason's teaching us how to do it. Hit the money symbol next to the chat. Then it will give you 2 or 3 options. One of them is gifts, and you enable it. Aha. Carrie, can we get a better name than survivors? I honestly feel more like a badass. I didn't just survive. I kicked butt a month. Tell me, because I don't like to say victims, because I don't think that you should be labeled a victim, right? So survivors was a term that I kind of came up with. So yeah, hey, listen, Carrie, if you've got a better term, I'm open to ideas. I listen to everybody's ideas and I implement them often for, merch, whatever. All right, badass thrivers. Okay, badass thrivers. That is right. You are all badass thrivers and you are not alone. And guess what else? It was not your fault. It was not your fault. And sometimes you can turn that into your life's mission and use it to help others and children. And, kind of like Maya. Like, I think that Maya will probably go to law school. I mean, she's a genius from what we've heard. She's very smart. She's excelling in school. I think, did I read somewhere that she's not even done with high school and she may have already finished 2 years of college during high school? Did I read that right? She's going to turn this around no matter what happens. And it takes a lot of guts to get out there at 17 years old and sit there every day. And, you got to admire her strength, especially when she's suffering from CRPS. She said she won't go to law school. She says that now, Deanna, but, her thoughts can change. Listen, a lot of people hate lawyers. That's why in my description of my channel, it says that I'm a recovering lawyer, because although I don't actively take on cases anymore, I'm always a lawyer because I'll always keep my license and I'll always have my license. But people hate lawyers. People hate lawyers. It's like, oh, hi, my name is Melanie Little and I'm a recovering lawyer. Like, you don't want to admit it, right? So we'll see. Yeah, she did say during questioning, but I think he said, do you want to be a lawyer? And she was kind of like, I don't know. Maybe. Sarah says, I like being underestimated. Correct Melanie on her education. Yeah, because then you can always clap back on a cross, right? When you're underestimated, you can try and underestimate me. You can try. It's probably not going to work out very well for you, but you can try. Who knows? It could change. She could become an advocate of some sort. I'm sure she's already an advocate for chronic pain. patients and CRPS. And thank you, Jennifer Corman. Everyone should share Melanie to spread her videos. Thank you. Thank you so much. You know, it's only the people that are interested in this topic that are finding it, interestingly enough. And there was not a lot of interest in the beginning, but the interest has grown quite a bit, which is unusual for a civil trial that, you know, a medical malpractice trial without celebrities involved, let's say, right? Because, you know, I think Depp v. Heard was the case that put LawTubers on the map, right? People started watching trials on YouTube when that case came out, and there was such public interest in it because of the celebrity factor. But this is, you know, we're seeing this, and it's a non-celebrity case, but it's a very important case to a lot of people because of what happened here with the parental rights being stripped. Hey B, Melanie, so thrilled to have found your channel. I am so thrilled, Hey B, to have found that you have found my channel, because you have been participating so much, and I see that. Lita Legalese, she's about to turn 18 and she'll be able to say much more without her dad being punished for it. She's awesome. Yeah, yeah, Debbie Joe. Debbie Joe, they hate lawyers until they really need one. Yeah. Yeah. And you know, that's why my entire practice was based on contingency. I did not ever bill clients by the hour. I felt so, like, I don't know, gross or dirty doing that. Like, just sending somebody a bill at the end of the month and, you know, billing these lawyers. Or, well, Kevin Costner was one of the first videos that I did on Kevin Costner's divorce, and his divorce attorneys are billing $1,000 an hour, $900 an hour. And, you know, they bill every 6 minutes. So if you're billing $1,000 an hour, you're billing on the 10th of the hour, which is $100 for every 6 minutes of your time. That's a text message. That's an email. Email will take definitely more than 6 minutes. So think about that. Think about sending your client a bill at the end of the month for tens of thousands of dollars and how gross that feels. So all the cases that I ever handled were on contingency. So I didn't get paid unless I won. So we wouldn't accept cases unless we thought they had merit and that they were winnable. And I'm sure that's what's going on here. You know, we got a third of whatever we recovered. If we didn't recover, we didn't get paid. So the client was never paying out during the pendency of the case. And we worked for free until if and when the case was settled or tried to verdict, you know, and 98% of cases are settled, never see a trial. So this is interesting. Yes. Seashell, my sister's going through a nasty divorce. She's already on her third lawyer. They're draining her dry. And the husband's like, yeah, and forget it. That goes on forever and ever and ever. I did do collaborative divorce for 10 minutes in my career after the church cases kind of sucked the life out of me. And I'm Catholic. So, you know, it was very personal to me, those cases. But then I thought, oh, collaborative divorce, like this is a really cool, peaceful, I'm Aquarius, you know, it's like peace, love, and happiness, a really peaceful way for people to get divorced without going to court. And it's collaborative, and they hire a team of professionals to help them through the process. And I don't know what I was thinking, because listening to other people's marital problems constantly all day long is if you're an empath, I don't recommend it highly. I don't recommend it at all. It really sucks the life out of you. So divorce law is it takes a very strong stomach to be able to handle those cases, because, you know, I can't leave my work at the door when I come home. It stays with me. I feel for these people, and it affects me 24/7. So that's a really, really hard area of law. And then you're sending a bill on top of it. I couldn't do it. I couldn't do it. A rate if you win. Yeah. Typically in New York, it's 1/3 of the recovery. In Florida, it may be different. And in medical malpractice claims, there's a sliding scale. So it starts off at 30% based on how much it settles for. And it drops down with each increment of amount of money. I think the first 250,000 is 30%. And then the more money that's recovered, the smaller and smaller the fee gets for medical malpractice. But straight negligence cases in New York are 1/3. I have seen lawyers in other states do 40%, maybe even 50% if it goes to appeal or trial. So I don't know what the fee agreement is in this case. Would I have taken on Maya's case? That's a great question. I heard that a lot of attorneys turned it down, and they were one of the last firms, and they took it. Would I have taken it out? Yeah, because, you know, I like to make a point, and I like to bring public awareness. So yeah, I would have taken it on for that reason. whether I won or not, whether I had to work on it for 10 years without ever seeing a penny, I definitely would have. And listen, I did work on those church cases for 15 years. Eventually, some of them settled eventually, but it was a lot of work. And then you look at a guy like John Ray, right, who's been out there advocating for Shannon Gilbert, back to the Long Island serial killer case for a minute. And I think that led to Rodney Harrison's resignation, quite honestly, when he stood next to John Ray in that press conference. And John Ray has been advocating for the family of Shannon Gilbert since 2011 or 2010 when she went missing. And he's been working for free for 13 years. And he's been trying to bring that family justice for 13 years. He spent at least $50,000 of his own money. And he has spent at least 50,000 hours of his time, and he's never been paid. So yeah, there are attorneys out there who are willing to do that. Hi, Black Rose. I talked too much. I wish I would have known that. 98%. Yes, I think we can. You have no idea. Can we do a vent session stream on divorce and how to survive it? Yeah, you know what? We could do that on a members only live if you guys want to. I don't know that we would do that as an open live, but we could do a members only, whatever you guys want. Hey B, I love Aquarius people. Some very important and wise people in your life have been the same. Yeah, we're known to be like flighty and peace, love, and happiness and sort of off on our own world, but we have feelings, we feel it. All right, so I think that we've been here for almost 3.5 hours. I have to go and do something with my kids. So if there's something else that you guys want to see regarding this, either later tonight or tomorrow before Monday, I mean, I do not think closing arguments are going to be Monday. If anybody has any other information on that, let me know. But they're going to be hours long. They've got to tie everything together. And based on this court filing that we saw, that's been locked up for the next 10 days. It can't stay locked up for 10 days because it's never going to happen. This is never going to go on for 10 days. But let's see. So if there's anything else that you want to talk about later or tomorrow, put it in the comments because that's easier for me to find than going through the chat. So as soon as I end here, the comments will become available and you will be able to comment, and then we can decide what else we want to watch. I kind of wanted to watch Maya's original testimony on damages that she testified to during plaintiff's case, because when we did Maya's testimony, we only did the liability portion. We didn't do the damages portion when she talked about all the things she can do, can't do, how this has affected her. And that deserves a little bit of a review because that goes to damages and that goes to how much money the jury's going to award if and when they get to that point. All right. So yeah, we don't know if they did the deposition yesterday. We don't know if it happened because the motion that we pointed out earlier, rewind if you didn't see it yet, was filed last night at 4 p.m. with those documents under seal. And it may be the article and the CMS report that we referred to earlier. Yeah, the word is survivors. I know that's the word that I like, but if somebody wants a different word, I'm happy to use it. Last question. What do you think happens next if the family wins a large money decision against JHACH? Do you think the hospital will offer a lesser but still large offer to settle and avoid going to appeal? Well, first of all, settlement conversations are confidential. So I think there have been settlement conversations. We just don't know what was offered, what was rejected. We don't know if there was a non-disclosure agreement or a confidentiality agreement included as part of the settlement. I think this case is going to go to appeal no matter what, sadly, but a lot of cases do settle during the pendency of an appeal because appeals are very expensive. I mean, think about how expensive an appeal would be in this case. You need the entire trial transcript. That means every single transcript from every single day since September 21st. It's going to cost tens of thousands of dollars just for the transcript. So it is a very, very expensive, lengthy process. So yes, this case could settle at any time. This case could settle during jury deliberations. This case could settle today. This case could settle during an appeal. If it's a huge verdict, that'll be appealed. If it is decided that the hospital has no liability and the jury dismisses the case, that'll be appealed. So there are so many things here at play that they've been setting up during all of these days of testimony and the private conversations we're seeing between the attorneys and the judge that the jury's not hearing. They've been setting it up for appeal since day one. So let's focus on, the good things that are coming from this, the public awareness of things that we've talked about, and we'll see what happens. Hopefully they can just put this case behind them and Maya can go on and live a normal life if that's even possible. But I do think she's going to be hounded by paparazzi for a long time. But it could settle at any time. Watcher says they offered to settle for 90 grand. 90 grand. And Maya's family turned it down. 90 grand, really? That's a slap in the face. I don't know. I don't know where you're getting that information or if that's true, but that's low. That is low, yes. And I hope Emotional Support Paintbrush, if they get a large settlement, they donate some to CRPS research. Yeah. I don't think it's about the money for them necessarily. A lot of chatters in the law and crime chat would disagree with me. I don't think it's about money. I think it's about awareness. And it's shining a light on a lot of things. So, just be cool, be kind, be classy. Going to make a t-shirt for that one too. Thank you to all of my viewers, to all of my replay viewers, to my moderators for keeping the chat classy, to my channel members. Thank you so much for joining and thank you so much for participating, because without you guys, I would not have a show. Please subscribe, like this video, feel free to share it out there, and come to me in the comments with anything that you would like to talk about during the remainder of this weekend. And good luck to all of the college football teams that you're rooting for today. Go Buffs. And I'll see you guys real soon. Thank you so much, everyone. I love you guys. Bye.